me applicable. Pray for listing of a matter for admission 9th or 7 or 9th February. Mela. Mela.
It is a Lordship, I beg to mention item number 14, my lord. I've been newly engaged in this matter. But this matter, there seems to be a disputed question of fact seems to be there in this matter now. Permitted to withdraw this, my lord, with the liberty to approach the civil court. However, my lord, the question of limitation might come. So, Section 14 of the Limitation Act, an observation may be there, my lord, at the time spent in this. My my lord, I've been newly engaged, my lord. I've already filed, my lord, on 30th of January, my lord. 30th of January. Deeply obliged.
Lordship, I beg to mention item 12 of today's meeting. Lordship, we have given the affidavit for vetting. Lordship, short date may be given.
Because I am for the petitioner in this matter. We have some urgency, so can it be taken up next week? Lord?
We have to file an affidavit in this case. Lordship, that's also. So, you don't want to file an affidavit. See, even September 2023. That is recorded, that you have received instructed. September, that is all, 27 September. So on the 4 months have elapsed, you have to expect in their profit. And then something affidavit, but if there are, it's required the authorities to verify if there's a claim and the thing. But just a short date. People not say we gave it 4 months. There was a date in between. You're not waiting to, right? So you have the inspectors in their pocket. The inspectors might not be comfortable. No. We have to know how to think for them there. Right. I will have very important. No, should then the method companies not to put the.
I am for the petitioner. I was for the petitioner.
Please, Lordship. Lordship, I beg to mention item number 13, Lordship. I'm appearing for respondent number 4 and 5. 13, Lordship.
The problem. Or 14,
13, Lordship. I'm appearing for respondent number
13. 13 or 14?
13, Lordship. 1 3.
But the 14 was in the.
Appearing for 13 years. 2 weeks time, Lordship. You need to file affidavit, Lordship.
What affidavit?
Affidavit in opposition for respondent number 4 and 5.
Property tax.
Yes, Lordship. PP dash, Lordship. Yes, Lordship. Yes, Lordship.
There is on behalf of the respondent number.
4 and 5.
That's it.
2 weeks time, Lordship.
Please stand by that affidavit and protect it. And what they are, saying,
Yes, Lordship.
is a matter. Something that is used by the respondent, there is by the form. Correct? This is a matter of the.
Obliged, Lordship.
May it please your lordship, I beg to mention an arbitration petition for listing probably on the 7th next week.
But it is 11,
Yes, arbitration petition. Yes. Actually, senior counsel is not there till 5th of the coming week, so probably on 7th or 8th.
the right. And to go out of time, prohibition.
Well, in fact, when the matter last time came up, it was that it will be taken up for final disposal. The issue is very short, There was a judgment of this honorable court. There was a judgment of this honorable court, whereby, the clarification issued by the government of India to the clarification,
That case is
my lord,
according to the clarification, according to it's not a clarification.
my lord. And that was set aside by this honorable court. And this honorable court held, my lord, two issues where arguments were advanced. One, that this clarification, whatever has been issued, is contrary to the international policy. And second, that in any case, there was no cabinet approval of this clarification, whereas the international policy had the cabinet approval. Now, this honorable court accepted both the contentions and set aside the impugned clarification. The matter was carried to the Supreme Court by the department below. SLP was dismissed. After dismissal of the SLP below, they filed a review petition before the High Court. And the review application was remained pending. During the pendency of the review application, the shared clarification, the cabinet granted the post facto approval to that clarification. Now, on granting of the post facto approval to that clarification, they have mentioned the matter before the court that in view of the post facto approval granted to the clarification, nothing survives, everything, and the review application was withdrawn. Now, 2-3 questions, my lord, which arises for consideration before your lordship is that, my lord, that the clarification having set aside by this honorable court, nothing survived, there was nothing in existence. If nothing was in existence, the post facto approval of that clarification, how it can be granted? Secondly, my lord, that the Supreme Court and other high courts have held
It goes back to.
for ex post facto, my lord, to approval to a clarification which has already been set aside.
That was the Let us circular.
My lord.
Circular dated, 13.
Item number 4 to 4. Well, I'm taking up item 4. If you also can take up item 4.
It is 2014.
14, well, absolutely correct, my lord.
That circular
Was set aside by this honorable court,
set aside by court.
and the SLP also was dismissed. So once it had been set aside, it no longer was in existence. And the question of, so the question of granting the pre-post factor approval to that circular does not arise. Second, my lord, to nullify the effect of a judgment, the effect of the judgment, the base of the judgment has to be changed. That means an amendment has so to be made retrospectively that if that conditions prevail, the court would not have passed the order.
But
Well, the base of the decision, on the basis of what, well, that has to be changed.
Yeah.
Now, that can only be done by the legislature. The executive has no power to nullify the judgment of a particular court, my lord.
Yeah.
Thirdly, my lord.
Yeah.
Even if the legislature does it, then also there must be a varying provision that whatever judgments were passed or whatever decrees were there will be of no effect on the basis of that. Here, there is no question of, there is no varying provision also because it was simply that it was been approved. There is no varying provision, validating. Because the lordship knows, my lord, when the retrospective amendments are made, changing it, a varying provision is there. There, whatever orders, court orders, etc. are there, they will have no effect in view of the orders, the amendment which has been made. Here, the question of varying provision does not arise because it was not done by the legislature. It was done by the executive. So my submission for lordship,
What has been validated by the,
my lord,
what has been validated by the.
it only says, my lord, that it has been given a prospective approval. That's all. Nothing else. In the review order, my lord, the clarification, the letter has been reproduced. I will press before lordship, my lord.
Yes.
Yes, review to order. I am placing before lordship the review order where they
So what has happened in the review case?
review the withdraw it because that
The withdrawn.
done.
So nothing survives.
Nothing survived. They said that because approval has been
So
granted
now you are claiming the subsidy, interest subsidy
on the basis of the judgment of this honorable court.
on the basis of the judgment and on the basis of that subsidy that was given in that NEIPP
My-
2007,
But whatever the actions were given by this,
97 and 2007.
whatever the actions were given by this honorable court,
So you are basically saying that since that this is a covered case, it will remain a covered case. And that the approval given by the cabinet
will have no
has-
effect.
will have no effect.
My lord. Your lordship may kindly see the order, my lord.
Yes.
May I read, my lord? So and so learned Solicitor General of Additional Deputy Solicitor General India, appearing for the review petition is placed for
Page
2, my lord,
page 2.
of the order, my lord.
What's that? This order?
Order.
Yes.
Placed for the copy of the letter number so and so dated so and so of the Ministry of Commerce and Industry, Government of India, which have a bearing on the instant review petition. The relevant experts, excepts of the so and so place. The Honorable Guwahati High Court in PDB Steel versus so and so in the order dated made the following observations. From the above, it manifests that the policy adopted by the approval of the cabinet cannot be withheld down or abrogated or modified in any manner as department of the government
This court has not interfered with the policy decision of the government as initiated in the NEIP 2007 and the mechanism involved in the implementing interest subsidy and the subsidy scheme. However, as the impugn letter circular, letter so is contrary to the policy approved by the cabinet, the same is interfered with. Taking this view, the batch of the petition is allowed. The impugned letter circular dated is set aside in past. The department, giving due precedence to the valuable observation of the honorable court, decided to move cabinet note for seeking a post facto approval on the letter circular dated 18/6/2014. Since the cabinet committee on the economic affairs by letter dated so and so has post facto approved the proposal for clarification issued by the so and so regarding the quantum of interest subsidy admissible in the case of the existing industry unit under substantial expansion and so and so, the very purpose of preferring the review petition gets exhausted. Hence, it is conveyed that the department decided to withdraw the review petition. You are therefore requested to intimate the honorable court and ensure the incidental formalities. So and so.
So they could have issued a fresh circular after taking the approval of the cabinet.
My lord.
That is your case.
My lord, my submission is that, my lord, that this circular and any other circular cannot have a retrospective effect. Even if the circular is issued today, it cannot
Yes,
have a
even if, but that is that is not an issue here.
not
anyway.
issue here. My lord. The question only is that, my lord, the SLP having dismissed the judgment of this honorable court attained finality. The review petition was withdrawn by them on the basis of whatever facts were there. So that has also been dismissed. Now, the plea which is taken by them is that this honorable court has held so and so, and
That
thereby,
is why, thinking that because of the ex post facto approval,
my lord,
it has revived that circular.
my submission for lawsuit, first submission is that something which is not in existence, how a post facto approval can be granted of that circular? That is no longer in existence. That has gone after setting aside of the said circular. There is no question of granting post facto approval to that circular. Secondly, as I submitted for the lawsuits, even for the repetition also, that this honorable court had not based a decision only on the basis of this one, cabinet approval. This was the second limb of the argument. And if your lawsuit kindly looks into what
What was the first limb of the argument?
first limb of the argument was that as per the industrial policy, I am entitled for the full interest subsidy. And the circular goes contrary to the industrial policy.
Petitioner entitled to
3% of the interest subsidy on the full working capital loan.
on the full on the full working capital.
And that the circular goes contrary to the industrial
So
policy.
it was on 2 points.
2 points, my lord.
One was on the full working capital. And number two was on the question of approval of the cabinet not being given.
Well, the first was that it should be as per the industrial policy. Secondly, assuming, my lord, assuming that the clarification has been issued, that clarification which has been issued was not without any cabinet approval. Now, both have been accepted. Now, the first part, they are not dealing with it. There is no amendment to the industrial policy. The industrial policy remains as it is. If the industrial policy remains as it is, the question of, my lord,
Even if the approval is given,
My
and
lord.
approval is held to be valid, it doesn't change
industrial policy,
the industrial policy, it still remains.
my lord. And judgments are there before lawsuit, my lord, that executive instructions
Cannot
My-
override
they
or
cannot
supersede.
supersede the decree. So on these three grounds, my lord, although they have not filed affidavit, they have only said in the last also that in view of this, these petitions have become infructuous. In view of the cabinet approval, these petitions have become infructuous. That was the submission advanced on the last occasion, my lord.
communicated to the department, that one opportunity may be given because the earlier.
Why? There's nothing here.
And one opportunity may be given and take on that where I don't that they would take because of that. On where of.
No, the last occasion it was submitted that this is the instruction only.
That was not. I think.
RKD is the-
I put many instructions regarding that.
The RKD Chaudhary was the additional assistant.
He still is, no? He still is. He's the deputy SGI. I know why are we wasting time?
Sometimes.
You just give me, what are the citations that you're relying
Well,
on?
I give you copies of the judgments, no? In the set of yes. The last Jammu
I
Kashmir,
do not know if the use of the word not in existence. Can it be, is that the appropriate word? When you say that when you set aside the circular, when the court has set aside the circular, 2014 circular, can it be said that it's not in existence
Well,
any
once it is-
longer?
once it is set
You can
aside,
say that, once it's set aside, then
once it is set aside, that no longer remains any order which is set aside.
it does not remain valid.
It doesn't remain valid,
That's all. So that is what,
my lord,
because the Supreme Court in various judgments has said
my lord.
that that instruction, that an order or notification remains valid till it is set aside by the court.
So some,
So I think I understand what you're trying to say. Only thing is I want to use the right word,
my lord.
which I am not sure is.
I'm grateful to you, Lossi Malak, for
Oh.
what the, in my mind, I wanted to convey that once a order is set aside,
Ah.
you cannot say that I grant approval to post facto approval to that one. How a order which has been set aside can be granted post facto approval?
So basically, once an order has become invalid, it cannot be validated in the manner it is being sought.
My lord. And the executive has no power. Secondly, there is no validating provision, and it is only legislature who can do it. The last judgment, which is latest judgment from the Jammu Kashmir High Court, which is discussed all the
Now,
judgments.
let us see.
My lord, this is the High Court of Jammu Kashmir.
Madam, one at a time, let us see. Okay, we might not dispose it of today, but at least let me be clear about, so that I don't have to listen again the next time. Yes,
So you will also kindly see the High Court judgment of High Court of Jammu Kashmir,
yes.
and you will also see page 12. 13.
Yes,
Last 5 or 6 lines, look.
yes,
We are aware.
yes.
We are aware that there is a presumption in the legislature and the executive acts against interfering with the vested and accrued rights of citizens. While the legislature enactments may be made,
We are aware that there is presumption in the legislation. Okay, then,
while the legislature enactment may be made, retrospective operation and can we interfere and take away the innocuous rights and under some exceptional circumstances, larger public interest of remedying mischief may interfere with and even vested and accrued rights of the citizen. However, this is not the case of the executive order or executive instructions. An executive order or instruction can, under the circumstances, be retrospective, nor can it interfere or take away the vested and accrued rights of the persons affected by it. They also may skip over, may come to page number 15. Vested or accrued rights, para 13, in the middle below. The presumption of legislative intent. That is also got in.
Yes.
The presumption of legislative intent is only against vested and accrued rights and not accruing of vested rights. The Union Parliament and State Legislature are well within their competence to legislate respectively, and by doing so may take away the accruing of vesting rights, that is, the rights which are capable of being exercised in future. But there is a strong presumption against the taking away or interfering with the vested and accrued rights. As is clarified by the Honorable Supreme Court in the judgment rendered in the case of so and so, this power is not available to the executive. That would mean that the executive cannot, by issuing orders or executive instructions with retrospective effect, take away the vested and exclusive rights. You know, may skip over and make up the matter. Paragraph 15.
There are many judgments with regard to trying to dilute the effects of a
I've
judgment.
given Supreme Court judgments also, the judgments I've given, but you'll also see para,
Okay, this is not saying
one paragraph,
anything.
I may read, para 27.
27.
I know.
Yes,
28, 28.
Yes.
In the constitutional scheme that we have, executive is under an obligation to obey the judicial orders. The legislature may, in certain circumstances, nullify the judicial or executive actions by enacting prospective appropriate legislation. However, absent with such legislation, neither the executive nor the legislature could set aside a judicial order permitting the executive to review, revise, or sit over the decisions of the court by issuing executive orders or instructions. Would tantamount to interference with the exercise of the judicial function of the judiciary. Your lordship may see to thereafter. I will take your lordship to para 13.
Para?
Para 13, look. The position of law has been explained by the Supreme Court in relation to the legislative override, whereas we in the instant case are compared with the executive override, which in any case is not permissible in law. The executive, as said above, is bound to comply with the orders of the court and has no power, jurisdiction, or competence to sit over or overturn such a decision by mere executive orders.
No, but how is this applicable to the facts of this case?
What they have done, they know legislation. Only the post facto approval is there. That is an executive power.
But how this, I do not know how this case I mean, I don't find the connection because out here, the approval is given by the cabinet, no doubt. But then the cabinet, this, like you said, since it is already an act, already a decision which has been set aside by the court.
Well, they want to-
It does not revive that invalid act, but the cabinet decision, can it be said to be is it a executive decision?
No, cabinet decision is not a legislative act.
It is nothing. It has to be acted upon.
It has to be acted upon by way of a legislative.
Cabinet decision is in any event, is not enforceable.
That's why I'm saying, that in this case, even if the cabinet assuming, they want to enforce that this is the cabinet decision, so it has overturned the decision of this court.
Cabinet decision is not enforceable unless the cabinet decision is acted upon.
There is a judgment also of, I think, of a lawsuit which is sitting in Nagaland or somewhere. That the cabinet decision only is a policy decision taken.
Yes,
And it must be implemented.
yes.
Now, for implementing it, it cannot be by way of executive, it has to be by legislature.
I do not know anyway, but it has not been acted upon.
Acted upon, only they are saying that it has been.
And it can be maybe acted upon by way of a new circular, maybe not by that. Of course, we will not go into.
And if assuming the new circular is there.
But still, it has not. It does not take away that point number one.
That it cannot overturn the decision. It can be prospective, but it cannot overturn the decision of the court. This on the court said, as per the policy, I am entitled full, and the circular goes contrary to it. So even if the circular is issued, it goes contrary to again. Unless and until the.
Anyway, we'll see. But then I'm not sure this is squarely on the point. Anyway.
Well, these judgments are only for persuading the lordship that what is the power of even the executive by any order, assuming on the basis of the cabinet, the executive order is also passed. That also cannot nullify the judgment.
Can you give me Supreme? No, anyway, this is by the High Court. No, that's why.
Well, at Supreme Court also, I've given two judgments.
Yes, give me.
One short judgment, your lordship, can you see 2002 9 STC 703,
Yes, yes,
last line, my lord.
yes.
By an administrative order of the government cannot overrule a judgment. Such an administrative order is no ground for review.
No, now the question is, what is that administrative order that you're talking about?
There is no administrative order.
Then,
except-
wha-
except,
that
my
is
lord,
why I'm
the
saying,
Prospective approval. You know, so absolutely correct, my lord. I am going little ahead, my lord.
we are going a little ahead, because there is no, there's an administrative order, according to you, would have to be on the basis of the cabinet
Well,
decision.
absolutely also correct, my lord, that there is no administrative order. It has not been acted upon.
Ah.
I was going little ahead, my lord, that
Yeah.
even if assuming, my lord, the administrative order is also there, then also, my lord, it cannot override or nullify the judgment of this honorable court. You are also absolutely correct, my lord, that cabinet approval itself will not mean that it has been something, and you cannot revive something which has been set aside. It cannot be revived. It can be revived only by way of an appeal or by way of review. Otherwise, interested parties, it becomes final.
What is the other judgment?
Well, other judgment is on the basis that how a judgment can be overturned, you know,
Yes, let me,
by
let me-
legislature. Well, also see 2017 one SCC 121
yes,
paragraph 48.
paragraph
48,
48.
my lord.
That's all.
If it is, my lord, some time taken, I will again make a further search to find out something in the line of your lordship has said, my lord, about cabinet and all.
Just some judgment on a cabinet decision by itself is not enforceable in law.
I'll absolutely.
And
What
to
is
be
the meaning?
enforceable, there has to be it has to be acted upon.
And secondly,
There
my lord,
are number of judgments.
Well,
Justice Ranjan Gogoi was a long
I'll
time
find out.
back, he has passed.
I'll find out. And also what the meaning of setting aside of the order.
You'll have to go to maybe Article 166, 162.
I'll find out.
You would be having all this already in number of your cases
Well,
already.
I will put all my efforts and also the meaning of setting aside, what the effect of setting aside.
Yes, effect of setting aside.
I'll find out. I'm grateful to you, Rossi, for pointing.
What is the proper word to be used?
Well, I'll give you.
Okay, right. Dr. A. Saraf, learned counsel for the petitioners. The petitioner's case is that, then you right, also heard Miss A. Gayan, learned CGC, appearing for 1, 2, 3, and Mr. And respond number 4, 5, 6, and Kalita. The petitioners are challenging the inaction of the respondents in taking steps for processing and disbursing the interest subsidy claim of the petitioners under the NEIP 1997, CISS 1997, and NEIIPP 2007. The petitioners counsel submits at the outset that the present case is covered by the judgment dated 22/5/2018, passed by this court in a batch of writ petitions, the leading case being PDP Steels Limited versus Union of India and four others. So, sir, he submits that the submits that this court in the above cases had set aside the circular dated 18/6/2014 issued by the Under Secretary to the Government of India, Ministry of Commerce and Industry, bracket Department of Industrial Policy and Promotion, comma, bracket close, comma, which revised the norms for determining the interest subsidy admissible in respect of existing industrial units which had undergone substantial expansion under the NEIP 1997 and NEIIPP 2007. Full stop. The petitioner's counsel submits, next part, the petitioner's counsel submits that
Page 100 SLP order.
huh?
Page
No,
100
no, no.
SLP order.
The petitioner's counsel submits that the challenge made to the judgment dated 22/5/2018 passed in the batch of writ petitions led by WPC 57/2018 had been dismissed by the Supreme Court in the Supreme Court on 12/4/2019 in Union of India and others versus Barak Valley Cements Limited and others. Full stop. Union of India, the no, wherein, full stop. Next paragraph. The learned senior counsel submits that in terms of,
The review application was filed.
huh?
The review application was filed.
Acha, next paragraph. The learned senior counsel submits that subsequent to the dismissal of the SLP by the Supreme Court, comma, the respondent Union of India. Oh, no, all of them. Acha, the respondents filed a review petition number 180/2019 before this court, praying for a review of the judgment dated 22/5/2018 passed in WPC 57/2018 and others. However, the same was withdrawn by the respondents by an order dated 1/2/23 on the ground that the circular which had been put under challenge, the circular dated 18/6/2014, which had been put to challenge, had now been given cabinet approval. And as such, the validation of the circular dated 18/6/2014, which had been set aside, having been completed, the effect of no, the provisions of the circular dated 18/6/2014 regarding the manner in which the interest subsidy was to be given to the existing industrial units which had undergone substantial expansion would now, what have I said? Please read. No, that sentence. It's become very long, I think. Has been given to the existing industrial units which had undergone substantial expansion would have to be followed. Full stop. Next paragraph. The learned senior counsel for the petitioner submits that the circular dated 18/6/2014 having been set aside by this court and the same having attained finality with the dismissal of the SLP filed by the respondents, comma, the approval given by the cabinet to the set aside circular dated 18/6/2014 that could not bring a dead horse back to life. He further submits that the challenge made to the circular dated 18/6/2014 by the petitioner by the petitioners in WPC 57/2018 and other writ petitions was on two grounds. Full stop. The first ground of challenge was that the circular dated 18/6/2014 was not a clarificatory letter clarifying the mode in which interest subsidy was to be made available to the industrial units, but was instead an attempt to modify the determination, was an attempt to modify the manner in determining the quantum of interest subsidy to be made admissible in case of the industrial units. Full stop. The second ground of challenge. If you have any problem, Kalpana, please tell, because I'll forget. I'm using words that I don't remember. The second ground of challenge made to the circular dated 18/6/2014 was that the circular dated 18/6/2014 could not have whittled down or abrogated or modified the manner in which the interest subsidy was to be given to existing industrial units in terms of the NEIP 1997 and NEIIPP 2007, in the absence of the approval of the cabinet. As the as the giving of interest subsidy was a policy decision of the state. Full stop. Next para. The Learned Senior Council thus submits. The Learned Senior Council submits that while the respondents have now tried to revive a dead horse on the basis of an ex post facto approval given by the cabinet to the circular dated 18/6/2014, which has been set aside by this court and attained finality, comma. What did what? What did I say? On the 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 decision of the decision of this court in setting aside the circular dated 18/6/2014 on the first ground itself, the first ground cannot be changed by the approval given by the cabinet. He submits that to nullify the effect of a judgment which has attained finality, the base of the judgment has to be changed. In the present case, no such change has been made to the base of the judgment, which can only be done by legislation. He also submits that there is nothing to show that any retrospective effect is to be can be given to the circular dated 18/6/2014 only because of the cabinet approval given on, when was it given?
Review of the year. The cabinet approval by letter 18/12/2022.
18th of 2022. He also submits that executive instructions cannot supersede the industrial policy of a state, as no validating power has been given to the executive. Mm, That's all.
Madam.
Miss, on the prayer of the causes for the respondents who submit that they may be given one last chance to obtain the instructions. The respondents councils, the councils for the respondents are given one last chance to obtain the instructions in this matter. On the prayer of the councils for the respondents, leave the matter on. No, you said you gave a date. You cannot change like this, madam. I can dispose it of now also. I remember the date. I'm just hoping that you'll mention the same date. If you don't mention, I'll mention it.
Lawsuit means fixed another matter 15th.
Huh? You said 12th. Then?
12 is holiday.
Holiday. 12 is not holiday.
It means
No.
12.
12.
13.
Who will not be available? 9th? Look, there's hardly any, what instructions do you need? This is basically a question of law. There's nothing. In fact, you are supposed to tell your clients that this is the law. They're not supposed to tell you what is the law.
9th.
12th. 9th. 9th, have we fixed a lot of cases? I don't know. Yesterday we were fixing a lot of cases. Huh? No. Okay. Huh? Leave the matter on 9th. We'll try. Otherwise, everything piles up. No. And this is, you see, this, Acha, one of the issues that the councils will have to dwell upon. Hey, right. One of the issues that the parties will have to dwell upon is as to whether a cabinet decision by itself is enforceable or not.
And also the effect of the setting aside.
Huh?
The effect of setting aside of the order.
There are judgments.
Okay.
Supreme Court, there are judgments like
I find out Millard all.
versus state of Kerala. I don't remember state of Kerala.
I'll bring Millard. I should have looked into.
Two judgments. Two judgments are there. Very clearly it has been said. All decisions of the government are valid until set aside by the High Court, set aside by the court. So even if you they pass an order, it's valid. Even if they cancel the order, it is valid. So until it is set aside by the court. Only thing is, what is the term used?
Exit. But only one date, when the cabinet approval was on 28/12/2020.
Cabinet approval, 28th or 20.
I'm highly obliged,
Acha, one more thing. Just one more thing. Just right. In the case of state of Haryana and others versus Ram Kumar and others, 2002 9 SCC 703, the Supreme Court has held that by an administrative order, the government cannot overrule a judgment. Then another, right, in the case of yes, that's all. That's all. Can you put this in the file? This also in the file. This also in the file. Item number? No, you filed your affidavit. Let us see. Let us see. You filed it. Let us see now. You give me my copy. Madam, this will not do. Are you going to file a draft copy? Yeah, let us see the draft copy. Huh? Has the money been given by Jal Shakti? You see, let us not digress from the main issue. The issue is you have not paid the money to them. You have made them work and you have not paid the money to them. Now you are saying that 90% of the funding has to come from Jan Shakti. The issue is whether Jan Shakti has given the money to the state government or not. Not yet. How much has been given?
Paragraph number 10, Your Honor. 914.0 that has been received and accepted here as 13351844 has been that's state share respectively. The state share as they have already received your Honor.
Now, is this 100% of the state share or what? That much I understand, madam. Now, central share they have given 2914.20. How much are they supposed to give in total? How much this 2914 of 20? Now they are supposed to give 90%. Is it 90% of the amount? I don't think it is. What is the amount that they're supposed to give, Jan Shakti? You please tell us. You please inquire as to how much money is to be still received from the Jan Shakti people. You see, it's a very easy way of trying to escape your liability because I don't think works are done straight away for all the work. You'll be doing it partly. Next year there'll be some other new contractors, then the year after that there'll be some new other. It's not at one go that you straight away tell them to do things. I think you have diverted the money probably. So you take your instructions.
Obligement.
Retake instruction.
Item number 8. There's other thing, say that we already started looking into that.
Lordship, Lordship,
Other thing is that we, I think, we have reviewed the record. He has not submitted the required documents.
What is the required documents that he has not submitted?
Record is there. He has submitted other things, you know, record is zero.
Yes, let us see. Yes, what?
I have placed my notice. Some
my lord, regarding,
document has been submitted by you.
regarding,
No, first of all, madam, before showing me that record, as per the tender documents, what is the documents to be submitted by a tenderer?
my lord, page 15, my lord. of
Page
my
15.
Corporate petition.
Yes,
Serial number 8, my lord. Tenderer
Serial-
shall attach the tender with following documents, bank draft of the value of rupees.
so this has not been submitted.
No, she is saying that I have not, I have submitted someone else document. Now, my lord, kindly have a look at page 220, my lord. This is the comparative statement, my.
Yes,
My lord, serial number 3, petitioner's name appeared, my lord.
yes.
As a tender rate, my lord, then stamp fees, yes. Bank draft of offered rate, yes. Everything is yes, my lord. Now, this is their own documents, my lord. After settlement is made in favor of private respondent, my lord, they are coming with this particular thing. Only thing is banker check and banker draft, my lord. From within same city, my lord, it will be banker check, my lord.
Where is that?
My lord, in the remarks column, my lord. My
Yes.
lord, serial number 3, petitioner's name appeared, my lord.
Ah, yes.
So, court fee stamp, yes, my lord. Then bank draft offered, yes.
No, I'm all that. Yes, forget it. Now
My-
come to remarks. Banker check. Yes, what about it?
Now, banker check, my lord. The account is, the person belongs from the same city, my lord. Within same city, there will not be banker draft, my lord. It will be banker check, my lord. Even if I want to pay someone in banker draft today, within Guwahati city, my lord, it will be banker check, my. So, and now, my lord, clearance certificate. Specifically, their remarks is yes in the column, my lord. Serial number 3, my lord. Land revenue clearance of the certificate, it is yes.
No,
my
but one thing, Mr. Council,
lordship,
if you look at number 1,
my lord.
number 1 is also from the same post office.
No, that clause, my lord, itself in their resolution is there, either Venkat or Venkat draft, my lord. My
Yeah.
lord, kindly have a more.
No, is this the reason that you have been disqualified?
Now, they are saying that I have submitted a Xerox copy and someone else, she has just submitted before your lordship. That,
Shall we just see?
Reason has been, given by the document project, not submitted the required document.
What is the required document, madam? It's like saying,
Then my etc. later, he has submitted other things.
okay, not his document.
It's not his own. Yes, he has submitted, but not his own.
What is his name?
Baburam Brahma.
Baluram Brahma.
Baburam.
Baburam Brahma. No, you see, these are in Assamese and all. Please show me which one is the flag mark. The problem is these are in Assamese. I cannot read.
Sorry.
That's what I'll say. This is Raghu, this is Raghujit Brahma.
Yes.
Just see it. Who is this? No, it's okay. It's no need. He's here. This is whose name? Is there any Baburam Brahma here? Baburam Brahma.
For subsequent document.
Not here, Baburam. Baburam is not here. This is also Raghujit. No Brown. Who is this? Raghujit. Raghujit. Again Raghujit. This is also Raghujit. You have submitted only Raghujit. Who's
No,
Raghujit?
no, my lord, I have submitted all my documents, my lord. Kindly
Really,
have
I
a-
do not know.
No, my lord, kindly have a look at comparative statement. If I have not submitted my own document, they could have make mention in their own comparative statement, my lord. This is their own document, lordship.
I do not know. You have to go to now this court. You see, we cannot take evidence.
My lord.
Now these are disputed question of fact,
No.
but they have brought the record. I have got to go by the record. What else can I do?
Now, my lord, if this particular comparative statement issued on, my lord, 24/5/2023, my lord.
This only talks of documents. Of
Now,
course, one thing is that yes, there's documents they have submitted, but then now what can I do? The official records show this. All are Raghujit Brahma. Who is Raghujit Brahma, by the way?
So I don't know, my lord. I am Baburam Brahma, my lord. I have submitted all sorts of my documents and last settlement was with me, my lord, by virtue of this court's order, my lord. And on the basis of my submitted document, this comparative statement was prepared, my lord.
Who is this Raghujit Brahma?
Another,
But in the beginning, in this is Baburam Brahma. Acha, Raghujit is the guarantor. He is the guarantor. Okay. You don't know? Yeah, it is Raghujit Brahma, guarantor. Ah, Suniram Brahma, correct. He is the guarantor. Yeah, guarantor. What to do, Mr. Counsel? I have got to go by what the record said, and you will give you liberty to go to that civil court. The problem is this is a writ court. I can't do anything beyond this. Okay, right.
Now, only one thing, my lord, the comparative statement, my lord. The remarks made that use mega check, my lord. And only clear.
No, you see, comparative statement only talks of what documents you have submitted.
Now, my lord.
It doesn't talk of in whose name it is.
Now, my lord,
Because this is what I've been given. What to do, Mr. Counsel? My hands are tied. My hands are tied. What were the documents that you submitted? Do you have it? Do you have a copy?
No, my lord.
You don't have a copy.
Now, my lord, required document.
No, that's okay. If you don't have a copy of what documents you submitted,
My lord.
and how are we going to compare and contrast? You have left yourself open. Right. Right, mister?
Jail.
J. Laskar, learned counsel for the petitioner. And Miss R.B. Bora, learned standing counsel BTC for the respondent number 1 to 4. Then you take this order dated 3/8/23, paragraph 2 and 3, yeah, 2 and 3. Who is respondent number 5? Right, so no one appears, heard Mr. Swenson, then you write the first paragraph. No one appears for the respondent number 5. Though, as per order dated 4/12/23 passed by this court, service of notice upon the respondent number 5 was deemed to be complete. Then you take that paragraph 2 and 3, okay? Next. I have heard the learned counsels for the parties and have perused the official records brought by the counsel for the BTC. Pusta. It is seen that in terms of the meeting minutes of the market settlement committee held on 26/6/2023, comma, the bid of the petitioner has not been accepted as he has not submitted the required document. So, on perusing the documents that are a part of his tender documents, comma, this court finds that there are a number of documents. No, this court finds that most of the documents which the petitioner was to submit are documents in the name of Rugujit Brahma, Rugujit Brahma, son of Sudhiram Brahma. A perusal of the tender form shows that while the petitioner herein, while the name of the petitioner herein is Baburam Brahma, comma, the name of the guarantor is Rugujit Brahma, son of Suniram Brahma. Though the learned counsel for the petitioner submits that the petitioner had submitted documents which were in his name, comma, the official records, however, show otherwise. To a query as to whether the petitioner's counsel has copies of the documents he had submitted. No, it has copies of the documents the petitioner had submitted, which is tender documents, comma. He submits that he does not have copies of the same. In view of the above reasons, comma, this court would have to. No, this court has no other choice but to rely upon the documents which are in the official records. The same having shown that that most of the documents submitted by the petitioner are documents relating to the guarantor and not to the petitioner, comma. This court does not find any infirmity with the decision of the respondent authorities in not accepting the tender / bid of the petitioner. The, in view of the reasons stated above, comma, the writ petition is dismissed. However, comma, liberty is given to the petitioner to approach the civil court to civil court with regard to his claim that he submitted. With regard to his submission that he submitted, documents in his name, documents pertaining to his name. Comma, in as much as the same would require a recording of evidence. Where are the records? Huh? The next item, 9.
Right.
9, 10.
What is it? Let us see. What is the case?
My lord, page 19 is there.
Give this. 9. So in 9, 10, 11, you are going to file affidavit today. All three. Have you got copy?
My lord, I will.
You need to file any reply or what?
No, my lord, maybe posted up on 6th, my lord.
On 6. Okay, right. On 9, 10, and 11, you write. Miss R.B. Bora submits that she will be filing affidavit today. Affidavit in opposition today. And prays that the matter may be listed on? On 6. This is the matter on 6. Come on which date? Miss R.B. Bora shall produce the original records.
Lordship, one prayer, I may be allowed to go to the records of Baburam Brahma.
Are you allowed?
My. Yes.
So this matter of by Monday, I can. The reason was when for considering the bid of the requisition, I wanted to the IT return for the year 2023-24 was. That is the petitioner.
Is that ancillary or essential?
Otherwise, the art standing, it will be mandatory for the.
ITR.
To have the.
When was it submitted? At the time of opening of the bids or what?
Along with the bid, technically.
He submitted along with the bid. Then why was it rejected?
Reason was when he submitted this assessment for the year 2022-23. We were 23-24. So last.
Oh, 23-24.
Additional contention is that is the firm they submit auditor.
So we had time till September.
Huh?
According to the income tax act, we had time till 30th of September, since we are an audited firm. So we had not filed till then. So there is our stand.
Arjun will be being a party with. but-
Can we dispose it off now?
No, I will find it.
Let them file it.
You'll file it today.
So by Monday. I will.
You'll file it by Monday.
Yes.
Then when do we have it?
If they file it by Monday, we will also need some time if we need to file a reply.
In this one, affidavit, but this- that's not it.
Can
No,
we
what
take
is
another-
the stand going to be?
Then this one,
He did not file 23-24.
yes, page 28.
23-24, but 24 not ended.
No, 20 to 24 assessment year.
There is a,
Assessment.
we have mentioned is. Financially will be minus. Because I think it will be sometime August. First of August 2020.
Okay, all right. Mr. B always submits that. He will be filing affidavit in opposition by by 5th, 5/2. Accordingly, leave this matter on
15th, my lord.
on 15.
Couple of minutes.
Eighteen to 20.
Make your lordship. My lord, these three matters are identical in nature. Suppose the matter has come up for admission, my lord, your lordship may take up for final disposal. Pleadings are complete.
Should it go before Justice Mehdi or what? No. It appears that he's heard it a lot or what?
He heard it, my lord.
No, because out here it has been said, seal cover envelope is kept in the chamber of his lordship. So I'm just thinking. Anyway,
So, no, it-
whatever, either way.
he go wrong. Maybe said that.
So when do you want?
The recovery is, if it's not of the officer, because that is the mind of the opening of the file.
So it's not partnered or anything.
It's not important.
So I think he's holding this bench, Justice Mehdi. He's not here, no? Is he here in Guwahati?
Eternal method. Yes, perhaps this week he is in the eternal method.
Oh. Anyway, so you all are not ready today? You all are ready?
My lord, I can do the hearing, my lord.
Okay, no problem. Let's start.
Whether, my lord, that he will be relying on those that.
Okay,
Actually, if the cover is not available,
actually, yeah.
because court directive,
No, it says there, look. With lordship, now with lordship means last was with Justice Mehdi, so it must be, no, with me.
Order doesn't
That's how-
disclose that it is part heard, my lord, but.
No, that's not fine. Buddy Habum, with whom, where is the part? Can I have the registry? Okay,
Or let it be posted next week, subject to.
cover content of minus of the financial state, and it was open and again kept in the.
what is the issue here?
Issue here is, my lord, there were three tenders issued, where, my lord, three categories of bidders can participate. One is, my lord, this is regarding supply of micronutrients and, my lord, pesticides and weedicides. Now, the three categories which can participate in the tender process are manufacturers of those items, then dealers and distributors, and authorized importers. So petition.
These are all, I mean, they're manufactured outside, or they're manufactured inside India also.
In India.
But why do you say importers?
My clients, my clients are, manufacturers. They have got big industries, they have got hundreds. And one has, 1,200 distributors. Now, they fulfill all the criteria. But before the last date of submission of tender, a corrigendum was issued, which required that the manufacturers must have the experience of supplying to government and PSUs for the last 5 years. So, my lord, so far as my clients are concerned, my lord, they have got this, the second category, distributors and dealers. They are, my lord, my distributors.
They are not required.
No, they also require.
They are also required to have
They
their
also require.
experience.
But so far as the manufacturer is concerned, by imposing that condition, manufacturers are ousted from the competition.
Because they cannot supply. Or what?
No, my lord, we supply to the.
But why are
distributors.
you ousted from
We
the
do not
competition?
supply to the, my lord, government departments and PSUs because of the payment issues, my lord. And we have got the dealers, they sell it.
Ah.
But we also sell, but not to the government and the PSC. So that clause has been incorporated by way of corrigendum, debarring us from participating, although my lord, we are the manufacturers and we are ousted from the competition. Now, the issue that your lordship requires to determine is, my lord, whether that corrigendum is arbitrary and it was whether my lord, there was any reason recorded for that. Why did they do it contrary to the standard bidding document? Standard bidding document does not require this from the manufacturers. Otherwise, your lordship knows the, my lord, law that the author of the tender, they are the best person to decide. But then, my lord, that decision has to be tested on the basis of whether this is perverse, arbitrary, or malafide. These are the, my lord, 3 points that your lordship has to
So basically question of law.
question.
So so basically it's a question of citations or
And also understanding, my lord, whether the, on the documents, my lord, I'll show that, my lord, they don't have any reason, justifiable reason as to why this particular
correct.
corrigendum was issued.
Appears so. Is it a 2-bit system or
It's a 2-bit system.
if it's a 2-bit system, then the question of quality of the product will be known at the time of the technical evaluation stage.
Yes.
So if that be the case, you want to know how reliable they are or what? What is the reason for this?
Idea of for the last 5 from public sector undertaking. Initially, lordship was, we have admitted that it was invited in advertising only. Subsequently, going by the Procurement Act and the standard bidding document, lordship, we have we incorporated that in the corrigendum. And but we expanded the years of experience to 5, whereas the
Earlier in your earlier tenders, was that provision always there? That
No.
was never there for the first time.
It was there in some of the tender notice, it was there. That is not in the standard bidding document also, which
Standard-
they are bound to follow.
But lordship, standard bidding document has 2 categories. One is with regard to the dealer and supplier. In that clause, lordship, just say clause, subclause, lordship, they have to have the experience of supplying to the government or any public sector. And taking that spirit into account, but in the manufacturer lordship only, it was given that they have to be manufactured and supplying over the last 3 finance. But taking the overall the spirit of.
No, for the distributors, how many years supply?
Lordship, 3 years in our corrigendum, we have expanded into 5 years.
For everyone.
For everyone. It's a fair trade, lordship.
Okay, one thing, is there any distributor, your distributor, who is eligible?
Yes, my lord. In fact, it's a very frequent situation. I am the manufacturer. I am not eligible. My distributor should be eligible.
Okay, that is the thing. It doesn't seem logical at all then. We can hear the matter. He'll bring it now. Okay, we can hear it then. So your distributor, has any of your distributors given their bids?
That, my lord, I have to take instructions and give the, my lord, particulars of the my distributors who are participating.
Yes,
That-
please, if that, because that will strengthen your case. You see, that by itself
Yes.
would show the perversity of the entire exercise.
In fact, my lord, they can disclose this, the names of the participants. Or, my lord, your lordship has to give me some time to bring those.
Yes, because that will strengthen, you see, that will show how, that will show whether, if you allow his distributors to participate, and if they have that experience, qualification, then to debar the manufacturer, and I mean, it doesn't stand to reason.
In fact, my lord, my bid will be lower than the distributor's bid naturally.
No,
That's why-
that will be there. Bid will be much lower. That is one issue. But I'm finding it very ludicrous. At least it would be ludicrous if your distributors were there. But prima facie, I don't know how you can. What is the? You see, one thing. What is the basis for saying that you want this 5 years experience? There has to be a basis.
Lordship is that we have given you our, lordship, the 5 years experience is for the both, different.
No. I'm not saying it is. It may be for anyone. But what is the object sought to be achieved by having that condition?
Lordship, 5 years because if we go by the amount of the civil law requirement and the money involved. Lordship, in between the 5 years, there is the COVID period. Obviously, Lordship, none will have that turnover.
You don't have to. You can say anyone who has 1 year experience also is good enough.
That's why Lordship, it's a 5 years so that many can participate. And on the basis of the interim order, Lordship, they have submitted their bid that has been evaluated.
If you don't put that condition, many more can participate.
Lordship, in all total, Lordship, even if excluding those manufacturers who do not have the supply experience, but in terms of the coach order, they participate. There are many other satisfying all those conditions. Those were placed before the honorable court in the technical minute and the financial evaluation. Lordship, I can't say because it was in the civil court.
Otherwise, my lord, the requirement of experience that is there with the petitioner. That experience of supply, that we fulfill.
You'll have experience of supply to your distributors.
Yes. No, distributors also, my lord, the other private parties.
And so you just find out, so that will strengthen your case.
Or can it be taken up tomorrow, my lord, because the instruction I can.
Okay, no problem.
Yes.
Will you have time within, you'll get the required information?
Yes, ma'am. Although it is, my client is from Calcutta, but I can get the instruction.
If you can have persons who is eligible to participate as per the corrigendum, your distributor.
Yes.
Okay, right. Mr. M.K. Chaudhary, learned senior counsel, shall obtain instructions as to whether the distributors of the petitioner company have the experience qualification in terms of the corrigendum for taking part in the tender process. List the matter tomorrow.
Highly obliged.
In item number 8, my lord, I have seen, my lord, my documents are there, my lord. Let them file an affidavit, my lord. Those are documents of grantor, my lord. My documents are there.
The documents are there?
My-
Okay, where is she?
Let it be, let them,
Which, just you both sit down together
my lord, I have seen.
and just see which document is not there.
Only,
Whether it's original or not, it is.
let her file an affidavit, my lord. It may be fixed on 9th, my lord.
Just a minute.
Man.
I am saying something, please wait. Huh? Is it that clearance certificate, is it required in the, just a minute, clearance cert,
Whether he has submitted or not, it is not mentioned anywhere or rather.
clearance certificate from block. Concern block is not there.
Yes, the front of the right?
Photostat is there. So where does it say that original is required?
Other, all other, that are the front notification,
No, in the,
and where whether he is submitted or not, only in comparative statement.
You both please sit down and just look.
Sadly allow if there is. I may not tell you.
No, you just see, just look at this clearest certificate. The photocopy is there,
Well,
correct? Then the documents are all there.
And by.
GST one.
Attested, you mean?
No, it's not tested, not tested.
But where does it say that self-signed or self-attested is required? Where does it say? Normally the different thing, madam. Where does it say? You see, your contention is that because he did not submit the relevant papers, it is not the question of whether he signed it or not. You cannot change your stand. It's a question of whether the documents are there or not.
Remark that in fact that could be whether it's acknowledged or not. That also I have more. This record is given by me. So I may be not certificate
That is not what you had prayed for when we were disposing it of.
before it was acted. Other
You took the order. Right. We list it on Monday. You'll be ready.
Let it be on Tuesday, madam.
people not that. Other
Huh? 6.
6.
Okay, right. Just on the prayer, the party list the matter of 6. You cut everything. Huh?
Right.
8. Keep it. Keep it. Tomorrow, or you keep it. You keep it, or tomorrow. Okay.
Well, the case, losses are the last quarter. After they can depend whether the deciding officer is not there now. But then he lost it. This prayer, interim prayer, was not granted. The time was not because the issue I was asked to finalize counter. Lordship, they have a look at the prayer page 13. What is the prayer? The Lordship like to grant any. The main prayer, not just because the interim, Lordship page 13. Page 13. Supporting that directed order that direction not directing the page 14 respondent to grant some more time to deposit dues accumulated during the period. These prayer lordship, they have a due of 14 crores 32 lakhs 31,146.
They've got 14 crores.
32 lakhs 31,146. Now my lord,
14 crores 32 lakhs.
31,146.
Yes.
Lord, the order is part under section 14B. 14B is the power to recover damages by your debtors because of they are late, they are not paying it. And section 8, section 7I, it is each. If they make more delay, they will pay more interest. That is the provision. They will pay more interest. So if your lordship grant further time to them, the very purpose of this provision would be frustrated. And the lordship can have one small paragraph, the Supreme Court says the lordship will have a look at it. And the lordship will consider this. Paragraph 16. 1990. Paragraph 16.
92 to which
Page 250, lordship.
Yes. Okay.
Paragraph 16. Now read it now. The original case itself was one where there were delays in payment of contribution and explanation even were rejected. The order of the commissioner rejecting the explanation of the employer was not interfered with by the petitioner. There, the default related to the period from March to October 1975, and again from December 75 to November 76. The show cause notice was issued on 7/6/77, and in response, the evidence stated the revision was delayed due to difficulties beyond their control, and there were disputes between the partners and firm.
and the power cut 60%, with effect from 6 by 74. And there were a huge amount of road able to Haryana finance property. Our region government commissioner by the order dated 877 rejected all the concessions and had the obligation to pay this contribution into the fund was unqualified. The explanation of the employer was not accepted. Before could not be linked with financial problems facing the establishment. It was stated by the commissioner, terms of 50% employees contribution. Trust money to the employer for deposit of statutory fund. Delay in deposit in the fund to the contribution amount of each of them. So, my lord, delay cannot be a ground, it is for the delay the damages and the given. So how will also grant time, other time means the purpose of the act is different. Well, I'll find a response and also consistently, where, I'll ask for, 7 days or 10 days time. It's not showing here, because this prayer was vague when the battle was moved. And this lordship was not inclined to grant. Lordship directed me to find it before, I'll find it.
Lordship, what my senior has stated, Lordship, what is my submission is that, Lordship, against the certificate of recovery, we have already filed an appeal, and the appeal is pending. During the pendency of the appeal, the recovery certificate has been issued for this attachment order has been issued. That is what.
No, is the presiding officer, is he there? Do we have it?
No.
Now is not joined. The new government is not joined. Join
When is he joining?
That is building for my lord, the name of lord.
Where is his appointment order?
Appointment is, in fact, the last term. No, we did, this is not in here, no, the central industrial tribunal deciding of that is given the power to be a appellate authority under the fact.
So is he there? Is he there?
He is not, he is not. That's why, but my lord,
There's no one appointed or what?
we're not sure whether they were appointed, but then my lord, dual charges are given sometimes. Calcutta deciding officer.
So please find out where he's filed an appeal.
Lordship.
My lord, whether the appellate authority will also cancel or redact this.
Whatever it is, there is a provision, whether he can do it or not, whether just because out here also the CPC, there's an appellate provision.
Lordship.
Just because there's an appellate provision, what?
Till then, Lordship, till then.
Order is passed not to sell any property. This is that happened, not to sell. They're not.
No, we are not selling, Lordship, that I do admit, but their revenue is also been kept attached, Lordship. The revenue earning from that
They say you cannot
report,
sell
Lordship.
it.
No, we are not selling, Lordship.
They're not selling. the
Lordship.
property.
Lordship,
No,
they are-
interim order is not the issue. The issue is when there is an appeal
Lordship,
against the impugned order, why not send the entire matter to the appellate authority?
That your logic. yeah.
That is what I'm saying.
Lordship.
That is what I want to know, is whether there is an appellate authority or not. Has an appellate authority been appointed? Is this?
This is what your Lordship had queried in the last call.
Huh?
One deciding officer was appointed. He did not join, so substitute is not. There, nobody has joined. That is the, that is, government is legally valid.
So
What is
till-
submitted to
till-
your worship is,
Till then, Lordship, this may be state, Lordship. I am not praying for the whole,
Most is.
but till then, Lordship. Till
Why,
then,
why not dispose of the whole matter?
Lordship may, Lordship may, Lordship may.
Hmm.
Lordship,
So what is your case?
Lordship, we are just praying for the staying of this.
Why should it be stayed? It is not your money. It is your employee's money.
Lordship.
Why are you keeping your
No,
employee's
we
money?
are not keeping it pending,
Then you
Lordship.
give it to him.
Once we receive the payment from the government and for that initiative has already been taken,
Now,
Lordship. As I have informed in the last-
what money is from the government?
regarding this EPF amount that has to, because
They
ASTC,
will give it separately to them.
Lordship, ASTC doesn't,
Does it go through the, huh?
ASTC doesn't have their own resources, Lordship. They
Ah,
have,
okay.
they are
Government.
giving the salary from the government by taking money
That
from the
is-
government.
What is to be
It
done?
is a
The
poor
ASTC.
organization, Lordship,
employees contributions are there.
Yes, it is with them.
Lordship.
Employees are getting the salary.
Till then, Lordship, I am not praying for the whole, till then, Lordship.
No, sorry.
Means, since appeal is pending, Lordship,
Appeal is pending, but then there's no one holding the seat.
Lordship,
Then why did you come here?
Lordship, since they have or issued.
What
the
is your
order-
prayer here?
Attachment order,
Is
Lordship.
your prayer to send this case to the,
No, we have not.
then it is for this court to decide.
It is for this court and all.
So then I'll decide it.
Lordship.
I'll decide it. Now you tell me
Earlier-
why your writ
Earlier
petition,
also,
why
ACC,
should your writ petition be allowed? Your only ground is that if since the government has not given you the money, correct,
yes, Lordship,
for the pension,
Lordship. For this EPF payment, Lordship.
EPA payment, is it a separate payment given
Yes, Lordship.
or is it part of the salary?
No, it is a separate payment that has to be.
How, show me the heads under where it's given. For earlier times,
Ah.
how did the government of Assam pay
Pay from
the
the salary part only, Lordship.
from the salary?
Salary.
Then it's part of the salary.
Lordship.
Then if part of the salary,
Earlier-
what have you done with it?
Lordship, earlier also the same cases has been filed in 2017. I have given the order.
No, Mr. Counsel, that's not the issue. Just because something has been done earlier,
Lordship,
doesn't mean that we've got to follow the same route
Lordship,
all the time.
that up to you.
Now the thing is that you have to pay the pension
Since,
contribution of your staff
Lordship,
to them.
Lordship,
The government of Assam has already paid you the salary for that.
Lordship,
Then that means they have paid you everything. Now where is it? Where are you keeping it?
Lordship, that is what we have filed in the appeal. The principal amount the ACC is ready to pay. Only regarding that compensation and the late payment. That since ACC is a weak organization, that is why we have filed an appeal to waive off that portion only, Lordship. Since
Well,
appeal is
Can
pending,
this court do that?
Lordship, no, this
This
court,
is a statutory provision. This is
This
under the law.
this court, yes, Lordship, I do admit, Lordship, since this court cannot allow that portion, Lordship, that is why we have filed an appeal. And till the appeal is decided, Lordship, I am praying for only, my prayer is limited, Lordship.
That is not your case. That is not your prayer.
No, prayer is the, Lordship, we have challenged that the attachment order, Lordship. That attachment order may be state, Lordship.
Why?
Till then.
Why?
Lordship,
Why should it be state?
no, attachment order may be state, Lordship, because the appeal is still pending, Lordship. Let the appeal dispose of,
But then they are saying that there's no one to decide the appeal. There's no person is holding the post of presiding officer.
but since there is a provision for appeal, Lordship, that's why we have filed an appeal, Lordship, against that certificate,
Okay, we're beating around the bush. I've heard you.
Lordship.
No point. I'm saying you're saying same thing over.
Same.
Heard,
Logic,
Mr. I'll be dismissing your case. Heard, Mr. R.M. Das. Learned counsel for the petitioner. R.M. Das, no?
Lordship.
Yeah. But should we file it? Do you think affidavit necessary? No, no.
We are not here for seeking relief, only to state that attachment order, that is what we have prayed, Lord. Our prayer is limited. Lordship. During the pendency of the appeal, Lordship, we have,
Have you paid the principal amount also?
Lordship, we are ready to pay that amount, Lordship,
No,
provided
no.
they accept it. They doesn't accept, Lordship. They are accepting the whole amount. That is the main cause, Lordship.
Go beyond that. What is doing lordship will do, my lord, by, let me find the response, lordship will get.
No, you pay the principal amount. How much is the principal amount?
Lordship, that I have to, no,
You cannot have a cake and eat it too.
Lordship, I do
No.
it. If your Lordship permits us to pay the principal amount, then we can pay the principal amount,
Let them pay at least something for the time being.
Lordship.
Otherwise, where will they get the money now for the remainder of the money?
My lord,
And this matter is not, this matter is
Just a
already,
minute.
Lordship.
my lord, when they keep the salary, they deduct from the employees.
The pension.
And they keep it with them. How can it? This is breach of trust. This-
Correct.
employees-
Only problem now is that because of the penalties, the interest that has accrued on the said pension amount. Now that part they don't have money, it appears. Because they are paying all the pension and all that.
My lord, we grant them 15 days time to pay that amount, or 1 month time to pay the whole amount. That can, the lordship will fix the date, where we give them time in all the limit. 1 month, whole.
Whole amount cannot be given lordship because of that only we have filed an appeal.
How much is the principal amount? How much is it?
So there are various accounts, account 1 month basis, 36. That is the total is account maybe account 1, I cannot take two.
You see, there's a problem is we do not know how much is the principal amount. How much is the principal amount?
It is damages and the, what they required to pay is the damages and interest, not the principal.
No, principal is there, lordship.
No.
Because of principal, the damages and interest has accrued, lordship.
Yes.
Page 36, 14B and 17, 14B is damages and 17 is interest.
Okay. Not sure.
You see the forwarding letter at page 35.
35.
Minus 40.
This is given with the executing of the certificate. Belongs to- With the code number. This due under section 14B, 14B is debit. And 17 is interest. Not the principal. Damages and interest.
So the principal, have they paid?
No, principal is not there. Only the damages and the interest portion.
Principal is not.
14 crore 32. This one is only the damages and the interest part, lordship.
That you are-
Principal is not there.
Provided to.
Principal is not
That you
there.
are report.
For that only we have filed an appeal, lordship.
They'll have,
Principal is not there.
Huh?
they'll have to pay this. That will provide the order to the clear fact. We can
Let that
avoid
Maybe the APF Act.
14. Yeah. Fourteen B. And that friend wants to exhort the village remedy and then come below. If they want, I have no objection. Even wait. Till they
Huh?
in the opportunity states, he can wait below. He says he'll exhort that remedy. But if that be so, lost.
Let him withdraw. Let him withdraw because he has said that he's not said anything.
Lordship.
No, that's why. So that
This
is
is the
against the-
You cannot go both ways.
both. Yes, lordship.
He can do it, you give him the liberty to avail it. If he so wants. What in B, also in power to recover damage. That is a statutory provider.
Only problem is that because of your order, impugn order, now he cannot wait for the appeal.
Right.
That is his case.
No, my lord, your lordship will decide the whole matter. That's why I said that let me come, my responsibility. Within 10 days, we'll file. And then the Supreme Court has said, well, this financial problem is no ground.
You'll have to pay prima facie.
Lordship, for this only, we-
Right. Yeah, okay, right. Mr. SK Chakrabarti, he's the PK Royal Leonard Senior Counsel for the all the respondents.
sole respondent.
For all the respondents is granted 10 days time to file his affidavit of position. The prayer for interim order is rejected. Interim order is rejected. List the matter. after 10 days.
Till then, Lordship. Lordship, may I pray for till then, Lordship?
Next.
Next, Your Lordship.
Yes.
Matter to relating to payment of subsidy minor. The petitioner unit is the existing unit. As per the manor scheme, they have application for the expansion of the unit.
Let us see the scheme,
Scheme, yes,
2007 scheme.
yes. Is my lord that. Next one is. 21. That in persons of the Northeast Industrial and Investment Promotion Policy 2007, NEIP, issued by the Ministry of Commerce and Industry, Department of Industrial Policy and Promotion, file number so-and-so, that is 1st April 2007, the Government of India is pleased to make the following schemes of capital investment subsidy for industrial unit in the northeastern region, comprising of states of
No, so are we interested in this scheme or some other scheme?
applicability. Into this scheme, my lord, it is up to 17. 2007 to my lord, 31st March 2017. Okay.
Yes.
Yes, madam. That
Yeah.
is column 2, my lord, commencement and duration.
Up to
Applicability,
31/3/2017.
yes. Applicability unless otherwise circumstances. Unit should be an existing units which go in for substantial expansion and are located anywhere in any year will be eligible for capital investment subsidy under the scheme. The scheme will also be applicable to the following. So why not the scheme was for existing unit also or for new scheme also, new industrial. Here my lord that service sector and their column 2 medical and health services in the network. Anyway, my lord. Should I read the whole? Not
No, no,
Extend the-
no, to whom will it be applicable and from when?
Applicability, my lord, unless otherwise specified. All new industrial unit. 3, my lord. Clause 3,
Yes.
in first page, my lord, page 21, clause 3. Applicability, unless otherwise specified, all new industrial units as well as existing units which go in for substantial expansion and are located anywhere in any year, notice tangent, will be eligible for capital investment subsidy under the scheme. No, my lord, located in any year and they have for substantial expansion of the existing unit, they have filed this application.
So anyone who goes for substantial expansion will
Substantial.
be eligible for the capital investment subsidy, correct?
Exactly,
And it has to be done within this period.
within this.
Then,
Definition.
Let's look at this point of funding. Funding is actually incorrect. It's not for substantial expansion. it can be like, it can be down to the misleading look. It's not substantial expansions. It's a new unit they have set up and they have applied for applied to subsidy other new unit.
No, Mr. Just see. It says here, unless otherwise specified, all new industrial units as well as
It's
existing units
Exactly.
which go in for substantial expansion. So they're two.
One
Yes.
is new unit and one is existing which goes for substantial.
Correct.
So see, but while understand is submitted, Interlex he has applied for substantial expansion, which is actually not.
She has to be already an existing unit.
Yeah.
Exactly.
So now.
Ground floor.
Applications he has submitted before the industry department, is for a new unit, that's what I'm saying.
So new unit also is allowed.
No, new unit is also-
All new industrial units are allowed.
There is a point there, which I am repeating is that our submission is that he is applying for substantial expansion of an existing unit.
Okay.
That is in fact. Correct.
Okay, she should have applied for a new industrial unit.
The application is there next year, the application itself. So here it is very clearly stated it's for new. Unit. Because for new unit loss that pollution certificates and all these things are very important. So that is
Then
the
I have to
crux-
record a file additional
That
agreement.
is the crux.
In that, if some disputing question is that, my lord, because in the affidavit opposition, that is not been stated.
Anyway, let her start, let her finish her part.
Ground floor is the existing unit, same name. This part two is the first floor. First floor, they are setting up, my lord, new machinery, new expansion.
So according to you, first ground
Ground
floor,
floor is the existing unit,
ground
same
floor
name and brand,
is existing unit
exactly one.
and
First
first
floor,
floor is
one new
expansion.
unit. Exactly, my lord. Quote us,
Okay, next,
yes. Whether the proposed unit is new or an existing unit undergoing expansion. New. unit. Yes, also one. There is not a problem in my lord, everything is there, my lord. And my lord, I would like to place page 38, my lord. When the file application, my lord. Page 38, after visiting the unit, my lord, the functional manager has filed the report. Comments of the inquiry officer. Page 38, my lord.
yes,
Certified that I have examined each and every particular furnished by the claimant Messrs. Quality Pharma Products Private Limited, Unit 2. Here, my lord, you'll see specifically written Unit 2. Industrial State, Lahore, and all are annexes, relevant documents furnished with the claim and found them to be correct and beyond all reasonable doubt. I have also personally visited the unit on 11 January 2010 and verified land, building, plant and machinery component items belonging to the unit whose details are given below. It is further clarified that these details resemble the details furnished in the claim application for subsidy. I have also verified the prices mentioned in the application of land for land, building, plant and machinery component item with original documents and found them to be correct. Eligible fixed capital investment amount, so recommended amount 41 lakhs 53,433. Comments of the GM, General Manager. So here's my lord forwarded it. Thereafter, my lord, page 39. 35 will get forwarded. The general manager has excise to the letter written to the superintendent of excise. Intimation of conventional production, quality pharma products, private limited set up for new manufacturing unit under the name and style quality pharma products to produce tablet capsules. Also, we have started the production on 2017. The problem arose, my lord, regarding the pollution control board. That is the my lord, ground of rejection.
Page?
Page 40, my lord, application for page 44, my lord. The regional agriculture degree, my lord. Application for consent to establish of Messrs Quality Pharma Private Limited, Unit 2, Industrial Estate, so and so, so and so, so. So, with reference to the above side subject, it is to inform you that this office has received your application of consent to establish for the unit, Messrs Quality Pharma, so and so, Unit 2, Industrial Unit, so and so, so and so. The unit has deposited so and so and data amount along with the application form. So they have deposited the required amount before the, my lord, Pollution Control Board, and my lord, the application is available at this office and under process. So they have applied for, my lord, it is letter, my lord, dated 23rd March 2017. It is intimated that, my lord, it is under process, application is under process. Then, my lord, page 41, consent to establish. Consent to establish is hereby granted to Messrs Quality Pharma, so and so, setting up for manufacturing unit, tablet, so and so, so and so. So, my lord, consent to establish was, letter was issued, my lord. And there are.
That this is
two
only,
conditions
okay, so this is after the period,
after the period.
after the period.
Not exactly, yes, after the period, 17 August, they have, my lord, written to us after the period. Because government department, they takes time, but in this case, exceptionally, they have taken
A long time.
long time to issue, my lord, the letter, consent to establish letter. There are two permission required. One is, my lord, consent to establish, another is, my lord, consent to operate. Thereafter, my lord,
Where is that consent to operate?
yes, my lord, page 44, my lord. With reference to your application in the name and style of consent, the Pollution Control Board Assam is pleased to grant the consent to operate under the Water Act so and so 31st March 2019 under the terms and conditions as per appendix. You are also requested to apply for consent to operate for the year so and so immediately. So that took long time, my lord. 17 I have applied before the validity of the scheme, and they have, my lord, took time to issue the certificate. And since it is an existing unit, my lord, so, my lord, the committee should have been, my lord, committee should have been, my lord, accepted, and they should have, my lord, taken a positive view. Since already for the existing unit, the Pollution Control Board certificate is there. And second thing, my lord, it is a orange, my lord. It is not, because making, my lord, tablets, use, etc., my lord, medicine only. Not, it's not a polluting unit. There are such a problem arose here, my lord, that consent to operation and page 45. With reference to your application in the name and style above, the Pollution Control Board Assam is pleased to grant the consent to operate under the Iman subjected to pollution control measures taken by the unit toward the period and compliance of all necessary guidelines notified from time to time and strictly follow honorable court orders for such type units. If any and other the terms and conditions as per board's earlier letter that so and so, the condition total, grant of consent to operate will be automatically withdrawn if
Is
the-
this any relevance? Page 45, is it any relevant? Is it relevant?
No, not much, but.
Then why are you reading it?
26 within a month. So
Huh?
after, my lord, you are requested to apply for 24 and 25. Till then, my lord, they have given, my lord. Now, my lord, problem has come into an order, my lord, that page 46.
Page
Page
46.
46. The SLC meeting, my lord, 57 state level committee, they said, and my lord, it was rejected, 47, my lord. Agenda on confirmation of the minutes of the last discussion approval and all the claims in settlement. Last paragraph, last button, after threadbare discussion and obtaining the views of the officials of the banks, financial institution of the claim financed by them. The committee examined all non units, capital, subsidiary claim before the FLT approved 16 numbers of cases, referred 4 numbers and rejected 1 number of cases. The decision of the state level committee case is placed at an assignment, the missing ended special vote of time. So the last one, my lord, they rejected one, that is me, my lord. Holding that, my lord, page 50 is the page 5050. Addition of SLC, the case was rejected as the unit obtained consent to establish on 17/8/2017 and consent to operate on 13/12/2018 from Pollution Control Board, both after expiry of so and so, that is means my lord NEF 2007, 31st March 2017. It is beyond my control, my lord, because the official issue an NOC or something, my lord, certificate, consent to establish or consent to, my lord, operate. All these things are beyond my control, but I have applied, my lord, and since it is existing in it, they should have, my lord, considered. After, my lord. Again, my lord.
Now you see, I have seen the letters from the Pollution Control Board to you
Yes, sir.
with regard to your consent to establish.
They have issued, my lord.
Where is the letter regarding consent to operate? Consent to operate, the letter, page 44.
44. Lately, they have issued lately, that is beyond my control because it's. a
With
government
no,
department.
no. No, when did you apply to consent to operate? Where is your application? Asking that you should be
Applied
given
February
first.
or March.
Huh?
February or March, my lord.
Where is it? Show me
Yes, my
that.
lord, I'll show you. Take, I have annexed and closed here, my lord. When the application was filed, definitely before that I have applied, my lord. Application was filed. Because commercial production has fallen. Statement on. 11.5. Date of application. Receive your application, consent to establish. 8/3/2017.
8/3/2017. Where is it's
Page
not it's
40.
huh?
Page 40, my lord, 40, they have stated, my lord, that on dated 8.
This is consent to establish.
No, my lord. First paragraph, they have mentioned my application date, my lord.
Yeah, so
8/3/2017, yes.
no, maybe. But this is with regard to consent to establish. This is not your application for consent to operate.
My lord, within one application, they will, my lord, they submit for the point.
So where
Or
is
I
your
have
so
to
where is
check
your
the
copy?
records, my lord.
So where is your copy? You don't have a copy.
I have to check the record, voluminous records is there.
Maybe. It's only one page.
Here, my lord, they have stated, the regional executive engineer, they have stated, my lord, our application is dated, my lord, 8/3/2017. Here, my lord, again, if I go through, then my lord, consent to operate, the same date, my lord. Consent to operate, application, if your lordship, pick up at 2 or give me some time, definitely I'll place the application, my lord.
Anything else?
Yes, my lord. Because, my lord, I filed the additional, not additional, opinion reply, my lord. In that opinion opposition, they have filed the opinion opposition. Industry government, they have put it. Country Pollution Control Board, page 76, paragraph 6, my lord.
Yes, page 76.
Yes, my lord. Paragraph 6, the industry department is stated, my lord, that so stated as per record, the pollution control board Assam issued the consent to operate certificate so and letter and issued the non-notification and all. So nothing much they have stated in the affidavit manner. Paragraph 9, they have again stated my lord, that inside denies so and so, intern on the so and so. Now I've replied all these paragraphs, my lord. That is my lord. Next, my lord, my if it will reply, my lord. Here, paragraph 5, page 90.
Page,
90.
yes,
That is because since the mention of the person, this the petitioner company so and so is a unit to company of its parent company so and so situated in the same compound which is situated at industrial set so and so. Company so is a registered company which has been registered under the company law. The original parent company so and so Pharma Quality Products was started in the year 2005 and the Pollution Control Board has issued NOC that is consent to establish on 27/6/2006 and consent to operate on 30/10/2007. Earlier unit, my lord, and in the same compound. It is in the same compound, ground floor and first floor. So copy of the NOC letter so and copy of the consent to operate so and so, pollution control board. I have annexed here, my lord. It is, my lord, at page 97. Quality Pharma Products so and so. So this is the consent letter they have issued with details giving, my lord, for the first unit. Therefore, again, I have stated, my lord, and statement the question. The unit petitioner has intimated, paragraph 6, when I'm reading, is that you intimated the same by submitting a letter to the Executive Pollution Control Board, Assam by letter dated 20/1/2016 and thereafter on 19/1/2017, which has been received and sealed on 20/1/2017. However, the petitioner has somehow misplaced the intimation letter 21/2016 and could not be traced out the same. Copy of the letter dated 19/1/2017 submitted before the Pollution Control Board is annexed, there is annex, it is affidavit. Next, let's see. New unit from the perspective. We would like to inform you that we are going to start a new unit in the name of Quality Pharma Products. Unit 2, in the unit we will be manufacturing allopathic medicine and food supplement. So this is one of the application, my lord, that is 19 January 2017. Earlier, my lord, they have
what are you,
16
what,
also, that is misplaced.
you have misplaced,
21/2016.
you have misplaced all the important documents.
They didn't think that, my lord, they have to come to court and, my lord, keep everything in them because, my lord, company run by, my lord, the officials and the staff
Oh.
only.
All the documents that were supposed to decide the case, and you have misplaced it.
So they have applied, it is not disputed, my lord, 17/1 letter is there, January.
For what?
Then they first
They have applied for what?
for consent to establish and consent to.
Consent to operate, I have not seen it.
Okay. So, Lordship, as regards that date,
See,
the petitioner has been able to come out here. I'm not sure, but then I try to find out the next.
let me finish, my lord, give me 5 minutes. Back will never.
Before that,
No problem.
Lordship
No, no,
was
the
confused as
question
regards the
is-
date, so I just wanted to give the date.
Okay.
Just give the date, just give the date, yes, just give the date.
So the date I could make out from annexure 9, page 40. So this is the letter whereby we have addressed the petitioner.
You can answer.
Yes,
So the function to operate upon 2020. Then reference has been made here from the reference, the last part, from PCP.
2019, 18,
2/9/2018.
2019.
So this is the date when they have applied and the necessary fees has been paid. Thereafter, we proceed and give them the.
The consent to
Online
operate,
application number has given up the next.
the consent to operate, okay. Uh,
8/3/2017.
correct. So this is beyond the limit, beyond the scheme.
31st March 2017. Okay. Business revisions can written control increase to the consent to apply under the water agreement under the terms and conditions as per the state. You are also just to apply for consent to apply. It is for the next 1929. This is my lord page from page 44, my lord. I think we can make up, my lord, that consent to operate. Already, the certificate is, my lord, consent to operate. Page 44.
Yeah.
Yes. That is been given on 13/12/2018.
Yeah.
Wherefrom I could not make it out. Wherefrom he stated, my lord, that I have.
From reference, REF. Just before dear sir, it's REF. The last,
No, madam, that reference, madam, that cannot be on 2nd September 2018 because they have, I have to confirm it and my lord, then I may be allowed to file an additional application.
no need.
There should not
We have
be any
heard you.
confusion. No,
No.
it's a good case, madam, your clerkship. cannot
No,
dismiss the
madam,
case,
I have heard you.
Your
you
clerkship is in the
just-
intention of dismissing the case.
I might have any intention of whatever I think is proper.
Yes, ma'am.
I have heard you. Now let me hear this other
No, my
side.
lord, I'll still, my lord, I have to submit, my lord, the
Yes,
policy
yes.
of the government.
Yes.
Yes.
The,
The
you
policy
see,
of the
government
government
deposition, they can
action.
argue. Let me hear the other side. Yes.
It's a orange.
You can, in the meantime, if you can find out some other documents which shows that you have asked for,
Only one letter I'm submitting.
okay, one letter, okay,
Page 102, my lord.
102.
Pollution Control Board approval. The industrial policy in annexure so and so have given list of various industries categories as non-polluting industrial activities, green, orange, and red. It has been resolved that all these industrial categories are as non-polluting industrial activities and green category. The prospective investors need not have to go through the arduous process of obtaining consent or NOC from the Pollution Control Board before an industry is set up. The green and non-polluting industries can straightaway be set up under advice to the Pollution Control Board. The orange category of industries specified in Annexure 5 will be granted a simplified consent for a period of 10 years. In case of industries covered by the Environmental Impact Authority notification dated so and so, limits specified therein will be followed. The validity of the consent orders, as long as there is no change in the process and addition, deletion of machinery will be followed. Red category, my lord, 5 years. Orange category will fall in orange category for 10 years. Green category, industry so and so. So it is been specified that simply and letter is necessary. It is not going for the hardest process. It's a formality because it's a existing unit. A unit is already here in the ground floor. That cannot be the ground for rejecting my case for getting my lord. They are entrepreneur, they are giving bread to the other people. They are giving employment. They should be encouraged. For some, there is some decision also, my lord, that there the government is making the policy to help the entrepreneurs. And my lord, simply for my lord, a unreasonable ground that should not be rejected. Page 103, my lord, our list of industries under orange category, serial 27, pharmaceutical formulation. Page serial number 27, pharmaceutical formulation. So, my lord, this is a non-polluting industry. And already an existing industry is having licenses. So where is that, my lord, hazardous, my lord, even after application, before when they have applied within the period, my lord, how it can be rejected? And 23, yes, my lord, this is another line, 26, 104, my lord, connector. That Messrs Quality Pharma Private Limited Unit 2 is hereby licensed to manufacture.
And 103, what did you want to show?
This is, my lord, a letter, my lord, issued by the, my lord.
103, orange category.
Yes,
Your is which one? Serial number?
Serial 27. Pharmaceuticals formulation. Now, my lord, 104. That Messrs Quality Pharma Products Limited Unit 2 is hereby licensed to manufacture the following categories of drugs, being drugs other than those specified in Schedule C and so drugs and cosmetic rules 1. On the premises situated at Industrial Estate Lahore, under the direction supervision of the following expert staff. So, listen to the license authorize the sale by way of wholesale dealing and storage for sale by the licenses of the drugs manufacturer under the license subject to the condition of prevention. The license is subject to the conditions stated below and to such other conditions as may be mentioned. So this is the license. It was given on 23rd of March 2017. This legislation, why not, or the authorities, government authorities, they have issued with certain intention for, my lord, encouragement of the setting up of industries. If by way of all these things, my lord, somebody will delay, somebody will not issue, and my lord, the scheme is frustrated, my lord. What is, my lord, very unfortunate.
Your lordship, this policy by friend is it's not relevant at all here.
Anyway, let her continue, let her finish, let her, you'll have your turn.
Which some policy?
Anyway, let her.
No, no, NEIPP we have applied, my lord, not in Assam policy. Which one? Assam policy. It is, my lord, not policy, it is categories regarding the Pollution Control Board, because the Pollution Control Board is not government of India, government of Assam. That's why I'm showing the policy of Pollution Control Board, because the industry is in Assam. So, my lord, it is relevant what category, because Ministry of Commerce and Industry, government of India is not controlling, my lord. It's controlled by the government of Assam only. They are only trying to finding faults. Some books, my lord, I want to. Documents. I would like to place some of the judgments, my lord. And
How many judgments?
judgments, there is 8 judgments, my lord. I have prepared a note also, my lord. And this is the, my lord, booklet of the policy, my lord.
Okay, that's all.
Yes, my lord.
Yes,
Because
Mr. Kalita, one thing I want to know straight away.
Not
When you come to page 21,
21 is a scheme.
yes, that is the crux.
That is the.
No, 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 so please come.
Yes.
You see, the duration of the scheme is from 1st April 2007 to 31/3/2017. Where does it say in the scheme that expansion that is being done has to be completed within this time period?
I just explain. This industry with this unit which is applied,
Ah.
before your boxing.
Yes.
This is not expanding. It's the new unit that they have set up.
Okay, this is a
It
new
is
scheme.
an existing unit, but it's a new unit they have. set up.
Okay, this is not a, this is not a,
This is the thought of subscription. Your subscription expansion also definition is different.
Ha,
So
ha.
you need to spend only 25% of the capital investment that you have earlier spent.
okay,
Then you become eligible for substantial expansion.
okay.
But here also the application they have applied on the new unit.
Okay, where do we get that
Page
new?
27. Page 27.
Yes, sir. Yes,
Page 27 you also will find
Yes.
towards the bottom.
yes,
That table is there.
yes,
The table, there are two things also. There is one for new unit,
yes,
second column you also.
yes, oh,
They
yes.
have filled up all their expenses and all. this.
Yes.
And second is lordship, the other column is lordship, for existing unit, undergoing expansion.
Prior expansion.
Yeah, so like they'll have to give prior.
Okay, all that.
So
yes.
there it's nil. This, they have applied for under a new unit. It's not an existing unit which has gone for expansion.
Okay, okay.
Actually, also the issue is that.
So if it is a new unit, then it has to be completed, it has to start running, commence. But where does it say that it has to commence from this date?
Lordship, what is, how they are qualified, I'll just explain you.
Yes, yes.
Because lordship, this is the scheme. Okay? It has been done under the NEIPP policy.
And the IPP 2007.
2007. But that 2007 is there in the also get additional agreement they have filed. That is there at page 108. Because lordship, what is important is the commercial date of production. So commercial date of production has to be within this time.
Yes.
Then only they will qualify.
As per the
That
2000
policy.
107.
108.
108.
They are not defined duration.
Duration, yeah.
So all units as well as existing units which go for substantial expansion unless otherwise specified and which commence commercial production within 10-year period from the date of NEIIP 2007. So they have to come within that frame. They have to start.
By 31/3/2017.
They should have commercial production. So they have claimed that they have come, they have done it. So lordship, I again lordship, I'll trouble your lordship to take your lordship to pay special their application. Why lordship that hurriedly they have made all this? It was expiring, so they have to apply within the time period, so they have done. And what they have done, so doing so all this. So
Yes.
page 27.
Yes,
Page 27 lordship, serial number 3 lordship will find
yes,
the date of commencement of commercial production. So what they are saying lordship is on 28/3/2017.
yes,
So that means lordship that is within the time period.
correct.
Now this is for new unit by lordship. Now lordship will find page 28 on very relevant information lordship.
Page 28.
28.
Yeah.
Now this is like lordship will find serial number 9 details of land and building.
Yes,
So there lordship will see the B serial number B.
yes,
Land allotted by government agency.
yes,
So land has been basically allotted by government agency. That's what they have claimed. in
Yes.
their paper.
yes.
And that was given on 30/3/2017. So lordship, how a government land can be allotted on 30/3/2017 and they can go for commercial production on 28/3/2017.
If it was allotted 1 day prior, the building could not have come.
That is why, this is their document, their claim, and then will find at page 34. 34, what you will find, this is an inquiry report. Here also one relevant information also on this topic, I just wanted to point out. Page 34.
Yes,
So date of receipt of application is there. Initially 5/1/2018. Date of physical verification 11/1/2018.
yes,
Then also page 30.
yes,
Page 35 towards the bottom, what you will find. If the land allotted by the government agency, towards the bottom.
yes,
Then name of the agency, Government of Assam, EICC Dibrugarh. Date of agreement 29/3/2017. So what's it?
yes.
Then what's it in the next page?
Just a minute, just a minute.
What-
7, 4, 3. Yes,
Now, what's it, all the dates are what's it that within 2 or 1 day, the agreement has happened, land was allotted, then they have got for commercial or commercial, in fact, prior to the allotment of the land. So this
Already
is their-
existing land, no? Existing land, existing building.
So this is their application, so, and of course, what's it on the basis of this consent to establish and these things were procured later, and this kind of units cannot go without having this consent to operate and consent to establish, then consent to operate. Now, if they go commercial production before that, then they are in fact also, like, they should be punished. Under that. Without having this pollution control board certificate, how can they operate?
He has not
And
started
they
anything,
have,
my
they are
lord.
saying that they have got for commercial production before obtaining these certificates, and this is the new need lordship. They are trying to make out the case that this is an existing unit, we have already got pollution certificate, they're trying to make out the case, but they cannot make out the case like this, because they are the old documents, so it says so, it's a new unit. So on the basis of that, also because this has happened after the expiry of this scheme, and the period has gone, and then they have obtained this commercial consent to operate much later than the expiry of this scheme.
That's regarding the land document, my lord. Just 1 minute, my lord. Regarding the land document, it is, my lord, since 2004, lease deed. That is renewal of lease deed. 2004, paper serving. They have not made any whisper in the affidavit. So I cannot so matter unless a question is asked, my lord, or they have make this point in the affidavit position of innovation. So matter I didn't file all these, my lord, documents, land documents, because the principal is, my lord, he cannot argue beyond the, my lord's buildings. No, this is documents are there. They have regarding there, but this list did, my lord, deed of lease. This is registered on 3rd day of August 2004. Building was also existing, only plant and machinery. And that is the industrial set within.
In the restriction itself, they have particularly make a statement that it is for expansion.
page,
Page 9, page 9 in the. When the application says it's for new. Page 9,
Application, my lord.
the first paragraph. The continuation of paragraph 7.
Paragraph 4 also, page 7.
Read out.
yes,
It starts.
Paragraph 4.
Paragraph A. The petitioner may expect that after speaking to the application and petition of the Indian private project manager, general manager so and so, has forwarded the claim of the petitioner to one department, so and so for making substantial expansion of the. It's not for substantial expansion, it's the way it actually made out. It says for a need. They have applied the application of I have already got. Is my observation of a unit cannot go and we go for submission production. Without having this. So whatever they have submitted, that has been properly scrutinized by the assessor.
So that is the case. Yes,
Right, submitting the point that as regards whether under section 29 of the area correct, whether a unit industry can do commercial production without getting the consent to operate on the pollution control board with this method.
where is that?
In fact, for that matter, on the last occasion when the matter was taken up, the court only wanted to have a clarification on that point, specific point, whether a unit can function without the consent. So for that matter, we have put the final very small brief affidavit, whereby we have stated the dates when the consent were established has been given. Thereafter, the consent operates and
Affidavit by?
affidavit by the political report the next. Respondent number 6. His affidavit is in response to the order dated by
Okay, affidavit of the,
Respondent,
of requirement number 6. Which para?
paragraph 4.
Hmm.
Beyond that.
What does it say?
It specifies that.
This is of 2022.
Yes.
2022. Yes.
His affidavit is filed in response to order dated 32/2022, whereby I have been asked to specify as regard whether the unit can function without the pollution.
And what have you said?
And we have stated that without the consent to operate and consent to establish, no unit can function.
Where have you said that?
That is specified here. Paragraph 13. Paragraph 13, I have to also reproduce the relevance provisions of that.
Okay.
Paragraph 13.
Yes. Or, okay, that is there.
Yes.
And what about the submission made by the petitioner regarding this government of Assam industrial policy of 2008? Page 14.
Acting. The government of Assam. So this policy is not this scheme under any IPP scheme person. That is a separate policy promulgated by the state of Assam for this. So that does not have any kind of relation to this scheme for the policy. There, like under that policy, some industries are applying for some benefits or some kind of subsidies, then that policy will be applicable. Then how pollution control board certificate has to be taken, not to be taken, that has been prescribed. It's a different policy. Doesn't have any relevance.
There is no document to show that the petitioner was a existing industry prior to 2017, correct? Is there any document to show?
Yes, my lord. Land is also continuous, my lord.
Huh?
Land
no, is it-
also
is it there?
2004, yes, my lord.
Not there.
And in each and every paragraph 4 also I've stated existing. And my lord,
There may be
the
other
recommendation also.
which may be existing.
No, no, why is disputing without the
But
making
this
a
scheme
statement
cannot
whispering
apply
the-
any. Scheme applied under any certificate. That is there on your application. They may be having plan in this existing area. That's different. But this unit has applied because this is unit 2. This has been named as quality pharma unit 2.
So already from a unit
Unit two.
one may be existing, that's a different thing, but they have.
Unit
applied
one
on
and unit
the-
two,
They
my
have applied under the new unit. Correct. That is there from their application. That cannot. be-
I agree, typing mistake is there, my lord. Existing unit,
That-
existing unit, all these documents show that, my lord, that is an existing unit.
All investment, they're saying that on new investment, I've shown you, all investment, they're saying about.
Yes, you cannot eat a cake and have it too.
At 2 o'clock. And try to satisfy your lordship.
Okay. Right. Heard Mrs. N. Saikia.
My lord, I have to reply, my lord,
You can reply what do you want to say?
at 2 o'clock. It's already.
No, yes, but what do you want to say basically? Yes,
So
sure.
many points, and my lord, I'll submit the documents also.
Ah.
And my lord, it's a existing here, my lord, the general manager, district industrial, general manager also written, my lord, that it is hereby registered under central capital subsidies.
Okay, we'll sit at 2.
Yes,
We'll give the judgment today
Yes.
itself, don't worry.
at 2, my lord.
No problem. This is the 2 o'clock, huh?
File an additional affidavit,
No,
my
no,
lord.
no.
Because certain documents I found in this.
No, madam.
Thereof.
No,
My lord, the registration, earlier registration was of earlier unit is a registration under in the year 2004. And present unit registered in the year 2016. And my lord, I'm producing the documents, my lord. This is
Show me.
for the- Yes, my lord, Ganan Xerox and lot of. there.
no, not at this stage, madam.
And my lord.
Not after hearing you, madam.
And my lord, yes, my lord, I'm submitting otherwise also. Learned friend has not whispered anything about my lord Assam policy, not anything about land documents, not anything, so he cannot argue beyond his pleading. Now, my lord, everything has come out in plead, nothing is, so we would have reply in the affidavit, reply. But he has not bring anything, my lord, on the affidavit opposition. So beyond his pleading, he cannot argue. And secondly, my lord, either it is a new unit or a existing unit. I have got the documents. Your lordship ask for any, my lord, document to prove that it is a, my lord, new existing unit expansion. That is also does not make any difference. In this affidavit, in additional affidavit I have filed, it is there, my lord, but page 121. Does not make any difference, my lord. The central government hereby makes the following amendments in for Government of India notification so and so, 27 and so, capital with subsidy, page 121. The definition is given, my lord, new industrial unit and existing industrial unit. Got it, my lord?
Yes.
Yes. So definition, new industrial unit means an industrial unit which commences commercial production on or after the first day of April 2007, but not later than 31st day of March 2017. An existing industrial unit means an industrial unit which commenced commercial production before 1/4/2007. So almost it is the same, no? Document hai na? I have to refer. Secondly, my lord, that consent to establish and consent to operate. Consent to establish, after getting the consent to establish, they have to establish the unit. Thereafter only they can apply for consent to operate. And my lord, they have, after establishing and my lord, starting the trial production, my lord, trial commercial production, they have to apply for commercial, they have to apply for, my lord, consent to operate. Thereafter, the consent award. It's a manner the production that is given commercial production, that is my lot of trial production. That unit. Otherwise, if they wait for trial production also, the industry will be deprived of my lot the scheme benefit. Industry will be deprived of the scheme benefit because my lord, it may take some time. Obviously, it has taken time, and my lord, consent to establish has already been given means, my lord, they have been given, my lord, for establishing the unit. So consent to operate will automatically come, my lord, after necessary inspection. Here I am reading a statement. I could not make pagination also. It's the same. Or it's a bunch of document, my lord, that's why I'm asking for my lord to file it by way of additional affidavit. Yes, sir. First page, my lord, in that, my lord, certificate of registration under NEIIP, 2007. It was, my lord, done on 38 March 2017. Thereafter, my lord, second letter is, my lord, that subject new unit at first and second floor over existing unit. It is written by the general manager, who is the first authority to check the unit, my lord. He has that new unit at first and second floor of your existing unit at industrial set, so and so, so and so. With reference to the above, this is to inform you that the district level standing advisory committee in its meeting held on 30/12/2016 has approved your application for setting up a new unit and the same and style of quality pharma production, so and so, and first and second floor of your existing unit at industrial so and so, and to pay so and so. So, my lord, it also proves that over the existing unit, it was in the ground floor, first floor and second floor. The GM has himself written, my lord. Then, my lord, request for permission of multi-story building, so and so, so. With the general manager, my lord. We have written a letter. Thereafter, the old unit was registered. It is not the same unit. Old it was registered in, my lord, during the number 12/4/2004. Certificate of registration. Then, my lord,
This
again,
is registered where?
and that's Shillong, my lord, second paragraph. Company registration office at Shillong only. This is, my lord, old registration of the old unit, 18th day of August 2004. Registration and center subsidy. They are also, my lord, that dated 7/8/2004, and my lord, old unit was registered. Now, my lord, last letter, my lord, that with reference to the subject cited above as reserved by your office regarding delay in NIP agreement, we would like to state that we had duly applied to your office on 1/7/2017 and your beyond date of commercial production does not affect our claim payment. Further, the office memorandum joint secretary to the government of India, Bhaidi Maniman, New Delhi, the 31/15/2016 revised. It is clearly mentioned that all industrial unit which commence commercial production on or after so and on or.
Where is,
before
he has not
sunset
given a
will-
copy to this, just show it to him.
Yes, my lord, I
Mr.
can give
Kalita.
my copy because he could not make photo statement.
Let's see.
And regarding the pollution certificate, my lord, there is Assam policy followed because all this integrity. And so is anything there, my lord, regarding pollution? This is the policy document, my lord. There is no response because government of India has formulated a policy to benefit. And since it is, my lord, some unit may be in Assam, some may be in Arunachal, some may be in Mizoram. And They have to otherwise follow the policy.
This
of
document
particular
doesn't
state.
make any difference to the case, Lordship, because there was an existing unit, there is no dispute about this. And that was registered on that in 2004. There is no dispute about that. And this document, Lordship, is already there in on the record, Lordship. It is because, Lordship, when you to get the benefit under this scheme and policy, Lordship, I can have. Somewhat.
Regarding.
This is a mandatory provision here, Lordship.
Yes, but.
Oh.
Unit is already, my lord, the ground floor unit is already exist. So, my lord.
We are not disputing
consent,
about
yes.
that, like,
But
we are
for-
starting a new
No,
unit.
no, no, it makes a
And
difference.
another thing is that, Lordship, that
There was an earlier unit.
was there, we don't have to dispute about that. And Lordship, this certificate of registration under any IPP is a mandatory thing. Once you want to avail some kind of benefits under this scheme, you'll have to register, pre-register it. So this is only the certificate of registration. There is no doubt about this, there is no dispute about this, and they wanted to start up a new unit. The GM has said, okay, you start up a new unit, I don't have any problem in this. So this document doesn't make it.
So it is not an expansion of the
It's not
existing
an-
unit.
not
That
an
is what you're trying to
Consent,
say.
my-
It's not an.
Whatever your.
Their
lordship,
own
that
documents,
also does not make any
their
difference.
own document
is a
says
new
it's a new
unit,
unit.
New unit, then also, my lord, it is entitled. If it is the expansion unit, then also same, my lord, principle is followed. Only, my lord, for the purpose of, my lord, pollution certificate. That what I'm submitting, that, my lord, already existing industry is operating in the ground floor. And, my lord, the new unit is operating in the first floor and second floor. So why for this small issue, they should be deprived of the benefit, because after the commercial production only, they have to, my lord, before the production, commercial production, but it is a trial production. And, my lord, one decision I'd like to place, my lord, that is very essential. Because, my lord, each and every time they have to come to court, then only get the subsidy, my lord. There are a series of cases, my lord.
Only thing is that also that application which they have made,
Because,
that
my lord,
gives the
for petty
details
things,
about the
for petty
investments and all.
yes,
And
my
that created a huge doubt among them this.
And, my lord, land is also, land document is available since it is released on 2020.
It is their document,
2004.
2017, it is written.
Renewal. No? So, my lord, I'm placing one decision 2005-10 SCC, page 554. It is there, my lord.
2010?
10 SCC, 2005-10 SCC, volume 10, 2005.
Yes.
Yes, my lord. That.
Page-
Is it
page-
554? I have
Uh-huh.
given, my lord.
Tara?
Once it is there, my lord. Number. It is, my lord. Yes, second case, my lord, in the list.
Yes.
Yes. Here, my lord, that it is held. The schemes plotted by the state releasing grant of subsidy for industrial unit is to be set up in certain selected backward district areas have a benevolent and public purpose to achieve. And that is to promote the growth of industries in such district areas which but for the state encouragement would continue to remain backward and the industrial investment will not be attracted to such areas. Such schemes have to be construed with practical and pragmatic approach so as to achieve and not frustrate the purpose sought to be achieved. The benefit of the scheme ought to be allowed. If it can be done, the application should not be dealt with a hyper technical approach or in a pandemic manner. If the application filed before the cutoff date is substantially in order and satisfy the formalities expected of the scheme, then an opportunity should be allowed to the applicant to cure the defects which are not of substantial nature or are capable of being cured, so that the deserving units are not left out of the scheme. The test to be applied is whether in substance the application satisfied the requirement of the scheme or suffers from such defects and deficiencies which it taken into consideration would leave the application as no application in the eye of law. In the former case, the application deserves consideration and the minor deficiencies should be allowed to be made up or cured. In the latter case, it can be assumed that the application was not filed at all. So, my lord, consent has been given. Established to consent, established and consent of part both are given, but on later date, my lord. That does not mean, my lord, they will deprive from the, my lord, benefit of the scheme, because with some certain intention only the scheme is, my lord, plotted. And that is not in their control. To get a certificate in time, they may not wait. But here, my lord, run a train instead of encouraging the, because the government has plotted the scheme, they should not support if there is no much defect in the scheme, they should be allowed, because the GM, he is the authority, my lord, for inspection and recommendation. He has duly recommended the scheme, function manager duly recommended the scheme. But, my lord, bank official and other official, having, my lord, in the sitting in the SLC meeting, they have not realized the, my lord, seriousness of the scheme. So it is not that something they have violated. Everything is order. They have got all licenses, everything, excise, from excise to, my lord, pollution to everything. So for a minor date or something, they should not be deprived. Because it's in the employees and, my lord, my lord, director, it's have a far-reaching consequences. If they getting a, my lord, peanut, not, my lord, much amount, then, my lord, they will be encouraged to set up. If the intention is, my lord, to give the benefit, then, my lord, definitely they should be encouraged. Because it's already the Supreme Court has held, and each and every cases, I have found many subsidy cases, my lord. After getting from the court only, they get the subsidies. Otherwise, they are not getting. So many cases are reported. For some plea, they are rejected. Actually, my lord, behind the back, my lord, knows the mentality of the officers matter. It is described in paragraph 8 and 11. They have got the license. It is not them, my lord. Without license, they are operating. They are running for several years now. 70 to 20 for 7 years now.
What about this problem with regard to this land? This has been
Yeah,
given to you
yes,
only in
all the document,
2017.
my lord. I have got all the document. They have.
No, but then this is your document. Inquiry report. Huh?
Which one, my lord?
Their application, lord.
Your application.
They
Is
are
at
not-
page 27.
Yes, page 27. This is your application.
Yeah, that's
So many land documents, they have,
No, no, madam, please look at your writ petition.
land is also, my lord, taken from the government initially. Petition. Petition from. Just a minute, madam. Page, come on.
Page 20.
27, 28, page 28.
Yes. Yes, my lord. Here, my lord. Which.
Come to 9, 9B.
Details of land and building, land, own land, and so land allotted by government. Earlier, it was continuing from 2004, my lord. First land, my lord, it is the deed was, my lord, 2004, 29 days renewal, my lord. Because earlier lease deed was, my lord, that, my lord, has been, my lord, now this land, you also can you check for the satisfaction, or he may check also, my lord.
Yes,
Yes, 23. 23 to 24 on just. Land document. Land, my lord, earlier unit, then also, my lord, land deed was there, my lord. Because it's a government, my lord, industrial state, industrial state. So that is not, my lord, selling, they are giving on lease. 2400. I also check. 2004, yes, my lord, this is the original, my lord, document. It's a, my lord, government plan, my lord, within the industrial unit. The address on that, my lord, industrial unit, only lease is given. Subsequently, it was renewed, my lord. They've taken on lease, my lord.
So this is for a term of 15 years.
Then my lord, you'll see, my lord 17, this is my lord.
That means up to
20, my lord.
2019.
Yes, my lord, 23 also. Other two documents, my lord, 30 years. Time to time they are renewing, my lord. Because the government, my lord, government, please. They are not selling the place, my lord, it's a industrial unit, yes.
So before the agreement is signed, they have
In the-
started commercial production. Because they have started
Trial
commercial
production,
production and
trial.
come- there is nothing called trial and, I mean, how can you differentiate trial? It's a commercial date of production that has been defined in the document. That is a the term we have taken, take it. There
Otherwise,
is nothing
they,
like trial for commercial.
if they wait
production.
for the license.
And they have started, they on document saying that they have started on 28th,
That's a-
2017.
be a point, my lord, to debate.
28.
Actually,
2017.
And what was the last date?
Last date was 31st, 2017 for the scheme. So
Ah.
they are stating that
So
they got the agreement on land allotment on 30th. And before that, on 20th, they have started the commercial production.
19,
And they are stating, Lordship, another thing, they are stating that they have
19.
started civil construction and electrical works from 2015 to 2017.
where is that?
That is in page 36.
Before your lordship, my lord, 19 March, my lord.
That's all they are
The
doing.
new lease was on 19 March.
Page
That is
36.
of 30
Lordship,
years.
fine.
That is of 30 years.
Lordship, towards the top of it, Lordship, B. B small b, date of starting and completion of civil and electrical works. 10/12/2015 to 22/2017.
But GMS found everything in order, my lord. Why, my lord?
GM is
the
only a
Standing
recommending
Council
authority.
is taking
No,
objection. on-
GM is only a
setting up
recommending
the-
authority. Like,
Yes. yes,
SLC is not a
recommended.
rubber stamp. They have their own wisdom. They have seen it, scrutinized it, then rejected it. Only GM has forwarded it. They are not going to approve it. They'll have to use their own mind.
They are only rejecting and rejecting. Each and every case has to come to the court. Whatever I have done and any others are doing. Lease deed is there, my lord.
So the scheme
Can
is for the
30 years.
benefits. There is no doubt about this. Scheme is for the benefits, but it has to go to
What is
proper unit. There are a lot of lazy, I mean.
What is the
eligible
blunder
units.
he has committed that they will be deprived of their benefit?
So, who is like eligible, they will be getting it.
So many government departments, this is a document of NOC, issuance of NOC for registration of lease deed agreement. So many documents are government department, they have to process a lot money for renewal of the lease also. It is given on 9 October 2013 for a period of 30 years, my lord.
Yeah.
Your lordship may kindly note. Duly vested by the judicial department in accordance with government notification number sent to dispose 9 October 2013 for a period of 30 years. So this is not a ground for taking objection. The land, my lord, issue, that is not.
What
just
is the
on-
tag number? Anything?
Tag
Nothing.
number, no, not necessary, my lord. It's even a government land. And my lord, it's an industrial state. Your lordship might have, my lord, concept of industrial state. Small plots are allotted. By lease deed, not selling or anything. And because the boundary, power facility, water facility, everything is, my lord, everything is my lord.
But where is the allotment letter?
Lease deed, my lord, not allotment, lord. This
Lease
is
deed,
one
lease deed.
document.
This- this-
Judicial department and other things, my lord. NOC, this is an NOC. Lease deed, my lord. Before that, my lord, judicial department permission and other things necessary. Here also, my lord, Bamani Moidan industrial state is there. Soigaon industrial state is there. People are setting up industries, no, they are getting the land on lease. And power supply, other backup, my lord, infrastructure.
But this has
backup.
been handed over only in 2019.
No, 2004 lease deed also there. Separate documents are there, my.
But that is for that document. How do we know that this place is in the same place?
It is in, your lordship will see the in fact also industrial state. Dibrugarh, I don't know, my lord, how many industrial state is there. It is in industrial state. Any document, my lord, from their side submitted, my lord. That is in industrial state, and my lord, industrial state is, my lord, it is constructed for the convenience of the people, convenience of the industry, giving all backup, my lord. That letterhead as an address and this letterhead. Everything else would have given in opinion position. He has not pointed out all these things, my lord. Now, my lord, I am in difficulty because I could not reply officially, my lord. Because all these arguments beyond the pleadings he is doing.
These are from records only.
Records, no, you have
I
to
have
take the
not-
point in opinion
I have
position.
not brought it.
You are not having any file any opinion, you have filed any opinion position, but no, all these points are, nothing is noted. Kindly go through your opinion position. So I have to search for this document, that document. How can it, your lordship, permit him to argue beyond his opinion position, beyond his pleadings?
No, madam, this is your documents.
No, my lord.
He can argue on the basis of
No,
your
this is
document.
the, my lord, in the opinion position, they should have pointed out. Land is, my lord, not disputed, how do you need to run? All this GM has forwarded, all this excise license, other license, state license, everything is when they have issued. Without seeing the documents, they will not issue. So, my lord, each and every department, they have to serially file all the documents regarding land, power, everything. ACB has given connection. Otherwise, he is questioning, that is, my lord, actually, my lord, ridiculous, man. Because without this document, nobody will give any permission. Trade license, electricity connection, my lord, water, another whatever necessary, excise, central excise. Everything has to file all documents. Then only these are my process license are issued for manufacturing and other thing. So now, my lord, if that loan document is not there, this is not there, that is actually ridiculous because all these departments, 10 departments minimum are involved. And they without seeing the documents, without processing all these units, this is not the matter of argument here. How the industry operate without the documents, without land, without building? So, my lord, silly things, small things he's pointing out and troubling me, my lord.
You have said that you have
Yeah.
started commencing
Yeah, so
operation.
address is given. my
Just
lord.
a minute, madam. You said that you started commencing operation on 28 March.
Yes, my lord. Otherwise, my lord,
Can you
there's a
operate,
target.
huh?
There is a target. Otherwise, my lord, he won't be take benefit of the scheme. Before, my lord, after 31st of March, he will not be, my lord, take the benefit because, my lord, sometimes because of the licenses, because of the permission, it takes time because from
So,
10
so one thing is that if it's a separate unit, so then why shouldn't the petitioner be given the benefit?
No, Lordship, it's a separate unit. So so separate unit, they have registered under a separate scheme, like Lordship. Earlier, 2004, their existing thing was different. Now, 2007, they have registered. Now, for a new unit, they'll have to go through all the process. So now what they have got, like from their document, I have shown the agreement, fine, all the things, if we take it as fine also. Now they are declaring that like they have gone for commercial production on 28 March. And the scheme was there till 31st of March. Now they have hurriedly, they have done it. It looks like they have hurriedly, they have done it. And they have applied for consent to establish and they have applied for consent to operate, but without having those documents, they have gone for commercial. Land was allotted,
land was
as per
allotted.
their document, land was allotted.
No,
later.
that
So
cannot
there are a lot, I mean,
So that's why, my lord, I'm
since
again and again praying for
since
filing an
they do
additional
not have
affidavit, my lord.
those consent to operate as on date. So SLC has decided that this cannot be given benefit because after the expiry only they may have gone for commercial production.
Because
Because without having the pollution, they cannot start it. It's a panel of.
No, madam, one thing.
Yes, my lord.
They cannot.
That's why
you-
land
you see-
document,
you
other
see-
document I want to file, my lord.
No, madam, one thing. You said that in the ground floor,
Yes.
the existing building was there.
Yes, ma'am.
And in the first floor, the expansion was done.
First and second floor.
Yes, first and second floor. If that was the case,
Yes.
the ground floor, first floor, second floor, they will all be on the same land. It cannot be
Same
on
land,
different land.
Same land, same compound.
So if that be the case, then the government allotment should have been prior to that,
Much.
much earlier.
Madam, lease is extended 19, I think, my lord, October or something, 19 March, my lord. Lease did, I have produced, my lord, lease did. That's why I want to file all these necessary
No, but
documents.
how
my
does this help?
Level will not follow 1 or 2 days, my lord. Whatever documents I am having, I am filing it to day after tomorrow. Tomorrow it will not be possible, day after
This
tomorrow.
case, I mean.
Level will not for, if the case is, my lord, for last 6 months, case was not listed. Now it is
Maybe, I
listed.
mean, madam, this case was for the last 4 years.
Yes, my lord. Let it come on Friday, my lord. Monday. Let it come on Monday or Tuesday. Then why I should not be allowed to file the documents, my lord?
Well, because so much, we have not filed it for 3-4 years.
Issue was not raised. Issue was not raised. Not in opinion opposition, nowhere. Nowhere the issues were, only in argument he has been. He should have made it in pleadings. Then only, my lord, because the parawise reply is given, parawise is required to give parawise reply. Then, my lord, he should have pointed out in the opinion opposition, not to put difficulty to the council. Because it's a established law of the Supreme Court that beyond pleadings, he cannot argue. Where is his pleadings? Like regarding land, regarding other thing, well, where is pleadings? That he is having doubt about this? And why the GM, functional manager, other authorities? Is duly recommended. Thereafter, not so much a problem. And benefit is same. If it is a new unit or existing unit, that doesn't make any difference. And regarding address also, this is a letter written by GM, and address is given, my lord, that Lahowal Industrial Estate, Dibrugarh. So the land is in the industrial state. It belongs to government. They are issuing only lease deed. There is no question of buying and, my lord. Unnecessary, why you should be, my lord, deprive the poor entrepreneurs, my lord, they have taken loan from the bank, not from their own money. And because of the lockdown also, all these industries faced, my lord, very hard days, very hard days. Because they have to pay for their employee, they have to pay the electricity bill, even it is not operating, fixed charges there. So, so many things here, lordship has to look. I myself have the entrepreneur and having industries, my lordship. We have faced how, my lord, the loan has become double in 2 years. And, my lord, the fixed charge comes around several lakhs. So all these industries, they are going to very rough and hard road because of the, my lord, lockdown, particularly for lockdown. So, my lord, for petty things, petty reasons, my lord, small things, my lord, they will be deprived of the benefit announced by the government. That is very unfortunate, my lord. Nothing more to say. I've given so many decisions, your lordship may kindly go through, and each and every decision, my lord, the Honorable Supreme Court or my lord court has interfered and given relief to the industry. People who are giving employment, they should be, my lord, at least given liberal, my lord. Approach by the Honorable Court also. The council of nothing illegal has committed, not my lord. So why they should be punished? Will only think for a moment, my lord. The difficulty they are facing.
So illegality is that you have operated, you have gone for commercial production before obtaining the pollution certificate. Illegality is that you have declared yourself in your own document that before getting the land allotment, before signing that agreement, you have started commercial production. How can they do it?
19 October.
How can you do it?
19 March, 19 March. lease
And like, this is
agreement
her
started
document, this is her
That's
document,
right.
she has
That's
placed
right.
it. And she's saying, I'm talking silly.
This deed is there, and whether it's a land.
And why should I
industrial
plead it,
area, not for private person.
their
They are
own
not
document
buying
says
from
so,
anyone.
why should I plead,
That's
take
why
the
I'm-
pleading?
Once you have taken the plea, without checking.
Why should I do the pleading when it
yes,
is there in
taking
their
the
own
plea in
document, it is on the record?
On your pleading, there is no whisper in their pleading. You are arguing this, that point, and I have to satisfy your lordship for getting all this. There's no whisper about land in the pleading, no whisper about other thing. In the pleading, they should have. Beyond pleading, how can I argue all these points? I would have annexed all these documents in my reply. If there is any point is there in the affidavit in opposition. No whisper in the affidavit in opposition. That's why I request again and again that I may be allowed to file down these land documents, everything, to his satisfaction, my lord, then only he will not agree that I have got the documents and licenses also earlier and now. Only one is existing from my lord, the said my lord 25 months. Since 2004, it is a party. Registration was. Under the 97.
This certificate of registration is only with regard to change of office.
Chairman, 2004.
Yes,
It is also there, my lord. Another document.
where is your address?
Subsidy. Address, my lord, your lordship will
In
find.
Assam, in 2004, what is your address?
Well, from industrial, it's Lahwal. It is there. This was another certificate of registration. Industrial, same state, same my lord area, building, these are different because earlier they have given 15 years, then 30 years, then. Address is there, man. Industrial estate Lahwal. In all document, it is there, man. Address to the document, man, there also.
No, you have been, but where is your address? Okay, industrial
Well,
Lahore.
Hereafter. Industrial state. Here also your lordship.
Yes, what to do, Mr. Council? I think let her file her affidavit.
Because all, I mean, Lordship, what my humble submission is that, Lordship, what she is submitting is that there was an existing unit, there is no doubt about this. That existing unit was registered under 1997 NEIPV. Now, this is 2007 NEIPV. So 2007, they wanted to start a new unit. So they have applied for all this, whatever is required. They've applied for it and those have been granted. I don't have any dispute on this. What I was pointing out is that only thing is that like commercial production could not have gone. They could not have gone for commercial production without obtaining those mandatory certificates. And mandatory certificates were not there. And that is why SLC has rejected. So you cannot go establish a unit and you cannot go.
I get your point. One thing is that this land was allotted in 2017. So that means the new unit was supposed to be in that new land.
New land, yes. So
That could not have been.
So, and that, is-
Earlier
and that agreement was, there is their document also, 2017, they have got the
No,
allotment,
19.
they have signed the agreement.
19
And
months.
on this basis of this agreement, I mean, all these documents only.
Let me find
the
out.
SLC have rejected. Why a
Regarding
discriminatory
document, because it is also his fault. He has not mentioned any pushpar is there, my lord, regarding land, my lord, in the opinion position.
I need,
He should have written, no? You cannot make any argument.
Okay,
It is
heard,
not available
Mr.
and we are not to file.
no. At this stage,
heard Mr. Kalita for response number 1, 2, and 5. Mr.
Head Borwa for pollution.
Ms. Barwa for point number 6. And Mr. G. Das for point, and what do you want to do? You want to? For point number 2. For point number 3. Hearing concluded, judgment reserved.
oblige.
Land document, again, I want to show, my lord, that prior to DR, my lord, 2013 land document also there. So many lease deeds are there.
What is the timing matter? Call them, call 6 and 7. Okay, what is this? Item 16. Who is for item 16? Yes.
In this matter, some records are to be needed, Lordship.
Okay,
Okay, all for the records. Paying for something.
when?
5th of March, my lord, it is
5th to fixed too many. After that,
7th.
not that week.
Oh, yes, my lord. 19 March.
On the prayer, the parties, this is the matter. On the prayer, the council for the party, this is the matter 19. Yes. March. Oh,
Yes.
March.
Yes.
March. Okay.
Item,
Why March?
I need to file an additional affidavit.
No, why March?
Any day, because records are to be coming from.
Okay.
This vendor will be fixed on say 12 or 15 February, 15 February.
15 Thursday.
This is the matter of 15. Straight for by the part, process for the party.
Timing item 6.
Yes.
In this matter, your lordship had put an query that how much central fund we are about to receive from the above in this
Yes,
project. Lordship, as per information which I have received, 37.20 lakh of central fund.
Only.
Yes, lordship. Because of that only in this project only.
That is airport really there. And under this project, how much liability do you have? Altogether?
Liabilities is also this much of it, because state share is already we have given to all the parties, now including the petitioners.
Okay, you make an application, for impleading that. The council for the petition, Mr.
Mr. P.H. Govind.
P.H. Kumar.
Yes, ma'am.
Submit that he will be filing, he needs time to file an application to complete the
Ministry of Jal Shakti, Government of India.
Ministry of
Jal Shakti.
Jan Shakti,
Jal,
Jal Shakti,
Government of India.
Government of India. Accordingly, this is the matter after 2 weeks.
Jal.
In the next.
Seven.
Similar,
Check. Yes. Please, your lordship, a date may be fixed, madam, after 2 weeks.
You file an application.
Yes, ma'am.
If you do it, you will file it tomorrow, we'll hear it tomorrow. It's up to you, how fast you want to hear it.
Deep development.
Okay. Yes. Yes, madam.
In this case, we are not this thing. I do not have to pick.
You don't have
It
to.
pertains to Pulima Beach.
No, the issue is slightly more than that. The issue is, pertains to Article 2263. Whether it is mandatory or directory, there is conflicting decisions of this bench. I mean, division benches, two division benches. Besides, there being different decisions of various high courts. There is no Supreme Court decision on this aspect till date, as far as we know. So, some research will have to be gone into by both sides. And we have to come to a reasonable decision. So, what do you think? Will you be taking up the matter, or will the AG also be entering and helping us?
Its date may be fixed. I'll inform the concerned party. So, if it necessary, I'll ask the age group.
Yes, I think better. And we are also of the view that we will have a amicus to also, help in coming to a reasonable decision. Okay. Right. The question to be decided by us is with regard to whether Article 2263 of the Constitution is mandatory or directory. In as much as there are conflicting decisions of this court or the division bench of this court with regard to the above issue. Next, Ms. M. Kichi, the learned additional AG, Nagaland, pays for time on account of the fact that she doesn't have the brief with her. She accordingly prays that the matter may be listed on some other date, and by which time he would also inform the AG at Nagaland with regard to the pendency of this issue before this bench. Next. We are also of the view, we are also of the view that Mrs. MKG also submits that she will inform the council for whom?
For the applicants.
For the appellant. For the appellant regarding the pendency of this case. Okay. Next para, we are also of the view that the assistance of an amicus curiae is necessary to decide the issue before us. Accordingly, we appoint Sri M.K. Chaudhary, senior advocate, as the amicus curiae to assist us. Registry to provide copies of the pleadings to the learned amicus curiae. And to reflect his name in the cause list. List the matter When do you want matter? Sometime. List them, before this the matter is it, Mr. M. K. Chaudhary can also be, is also given the liberty to take a junior of his choice to assist him in the preparation of this case. List the matter on. Give a date. When is it convenient for you?
The 8th of February.
Too short a time for you.
No, means 8th of February, my AG is coming.
Yeah,
Yes, too much. Here,
okay, very good.
But then,
It-
but then
it is, yeah.
your lordship may fix it on another date because like on that day I will get it confirmed with the date of his country.
Otherwise, if he's coming on 8th, we can fix it on 9th. Or we can leave it blank, you can confirm and then we'll give the date.
Lordship, like, with regard to this, I have. Some
Huh?
convenience will be there on my part because like I have to scan the copy.
Okay,
Yes,
So when do you want?
so can it be in the last week of February?
No, last week of February, my brother will not. That week, he'll not be there from 19th. 19th to 1st January. So let us fix at least that day. We don't have to do it. At least let the parties be there so that, 8 is not 8, 8, huh? At 3:30. 3:30. At 3:30. There is no more due. Good idea. So, brother, okay, on 8th at 3:30.